the resource persons and guests on the dais, the guests of the dais and the participants of the dais, and of course, prosecutors who have joined us through virtual mode. I will take this opportunity to welcome all of you to this two-day training program, capacity building training program on the 3 newly enacted central laws. At the outset, let me brief you something regarding this program. But before that, I will like to request two of our prosecutors, Krishna Parija, Assistant Public Prosecutor Atgad, and Subhasri Jaina, APP Bhadrak, to felicitate our resource person, Dr. Sarfaraj Ahmed Khan, Associate Professor, WBNUJS, and Sri Siddha Sikdar, the Vice Principal of CDTI Kolkata. Thank you very much. Let me just begin with these words that this training program, this capacity building training program, was actually envisaged by the Honorable CJI, the Honorable Chief Justice of India, when His Lordship wrote a letter to our Honorable High Court, requesting the judicial academies to conduct programs of this nature for judicial officers, for prosecutors, as well as for advocates. The basic aim of this program was to build the capacity, enhance the capacity of the law enforcement agencies so far as the judicial officers are concerned, the public prosecutors are concerned, the advocates are concerned, in first understanding the law, number two, in applying the law, and most importantly, to bridge the gap between the existing law and the new law. Since both the laws will be there, both the sets of IPC, CRPC evidence and the Bharatiya Nyaya Sanhita, the Nagarik Suraksha Sanhita, and the Sakshya Adhiniyam, both the 6 laws, all these 6 laws will be there. They are going to stay for at least some time. So the law enforcement agencies must have this working knowledge, how to balance between the two. So this was the main aim of this program. In the first phase, we have conducted the training program for the judicial officers. And I will take this opportunity to acknowledge the help, assistance, and cooperation extended by BPRD, Bureau of Police Research and Development, Government of India, CAPT, Central Academy of Police Training, Bhopal, and of course CDTI, who are our training partners, the Central Detective Training Institute, Kolkata. They are our training partners for the last training program, for the present training program, and for all the future training programs to concern. We are indeed grateful to you, sir. And now I will take this opportunity to introduce the resource person for the day, Dr. Sarfaraj Ahmed Khan. Sir is the Associate Professor at West Bengal National University of Juridical Science. It is the national law school situated at West Bengal. Sir has got vast experience in the field of criminal law and all the procedural law that we are going to study. We have requested sir to discuss throughout the entire day the overview of Bharatiya Nagarik Suraksha Sanhita, additions, exclusions, modifications, then the reforms in the trial procedure, and of course thereafter the Bharatiya Sakshya Adhiniyam, and to conclude the new dimensions in assessing the relevancy of fact, primary evidence, secondary evidence, and all sorts of the nuances of the law of evidence, and most importantly, the role of the public prosecutors, for which you are here. This program is specifically designed keeping in mind the duty and the responsibility of the public prosecutors in the discharge of their official duties. Therefore, this day is going to be very vital for all of you. Sir, I welcome you to Judicial Academy, and it's our privilege that you are here despite your busy schedule. I will now take this opportunity to also to welcome Sri Siddha Sikdar, the Vice Principal of CDTI. Sir has always been instrumental in designing and implementing our programs. I was not present during the last training program, but what I have heard, Sir personally involved himself in designing and implementing the program. Today also he is here. I take this opportunity also to welcome him. Sir, I welcome you to Odisha Judicial Academy. And I also welcome the respected office bearers of CDTI who are here as observers. Please look at the setup they have made. They have designed the program. They have requested one valuable resource person to be here, and they have also sent their observers to understand what is the program, how the program is going on, what more can be added for the next program. So this shows the intensity of the training academies and their training partners in imparting the training. So it is requested that you also should give your part in understanding the subject, in cooperating with the training and asking valuable and relevant doubts. Please get your doubts clarified. So without wasting much time, I would now like to request our respected resource person, Dr. Sarfaraz Ahmed Khan, to kindly speak few words before this session formally starts. Sir, please.
Thank you, sir. I'm indeed grateful to Odisha Judicial Academy for inviting me, and that channelizes through CDTI Kolkata. Now, these kinds of training program, I'll be there with you to talk about the technical things throughout the day. But what I want to say in the inauguration time is that these kinds of a training, when we organize, it's more than training; it's experience sharing. So in the room, if you have a 50 odd number of prosecutors here and then many online, and say everyone has at least average 10 to 12 years of experience. So we have 500 years of experience in this room, and there cannot be any problem in the world which we cannot solve or find a way if we have an experience of 500 years. So that's the opportunity we normally get when we have these kinds of interactions. Training is not to train someone, but to discuss, deliberate, analyze, look at the new law, and to see how this law is going to be implemented from 1st July. The deadline is there for in front of us. So many challenges will come, many hands-on training maybe in their future, but this is another opportunity where we can find the ways in which we can ensure that we all are ready for 1st July when this law going to enforce. With these few words, thank you everyone, and then again thanks to Judicial Academy for inviting me. Thank you.
Thank you very much, sir. I will not forget that one word, 500 years of experience that we have now here. Thank you very much, sir. I will now take this opportunity to invite the respected Vice Principal CDTI, Sri Sibda Sikdar, sir, to kindly come here and share his experience. Sir, please.
Good morning, officers. And really, I'm happy to see you here as an August gathering here on overview of 3 new criminal laws. You are the mediator between the judgment. That is the final word, because you are going to offer the judgmental view to the court before the honorable court, and they are going to get motivated or demotivated, whatever way we produce before the court. So that will be our main motto. And the new changes over this new criminal law, 3 criminal laws. So this better idea is to get what is the changes made in these. What are the difference between the changes? So that will be our main motto to understand. So we have invited 2 faculties from WBNUJS and one eminent faculties from CFSL Kolkata. He is also here, Ramesh sir. He will also take your classes. And our Deputy SP, Sri Pradeep Kumar Das, he is the training in charge, and he makes the module precisely to understand the law which is changing today in new criminal laws. So I wish you all the best here with the 2 days program, and I thank you once again to this Odisha Judicial Academy to invite us here to deliver lectures on the same subject. Thank you.
Thank you, sir, for the help extended by you. And now, since sir has announced that our respected resource person, Dr. P. Paul Ramesh, Assistant Director, CFSL Kolkata, is here, I also take this opportunity to welcome you, sir. He has 2 sessions tomorrow, and we are fortunate that we are having a domain expert of that kind, right? We are all of us are acquainted with SFSL, but as I know, CFSL stands on a different footing. They have their own set of high values and standards. So whatever doubts you may be having, please keep reserved for tomorrow to get it clarified from him. With these words, once again, I thank all the respected resource person and guests on the dais, and the respected participants, both who have joined us physically as well as virtually. We will now end this small inaugural session, and we'll directly start the technical session 1. I'll request all of you that The first technical session will end at 11:45. So 11:45 to 12 o'clock, there is a 15 minutes tea break. And during that tea break, we will all assemble at the portico of the academy to have a group photograph. So I request all of you to kindly join us for a group photograph. And thereafter, we will start the next technical session. So with these words, I thank all of you. So we will now be joining for the first technical session. Thank you very much. So you can directly connect from here if you want. I can connect. Sorry, just okay. So the bus is
So, business will start. So, two laws which we are going to discuss today. I'm taking this initiative to start discussion. So, I'm not saying it's training, it's a discussion with you and see. We must understand what are the changes which are there, which are important changes and how we can improve upon it. So, we look into BNSS. What are the changes are there? So we know the CRPC in its place, Bharatiya Nagrik Suraksha Sanhita, which came into existence and going to be implemented from 1st of July. As sir says in the inaugural speech, that despite we are having all three laws, new laws, for next few years, we have to struggle with both laws, old and new. So for new cases, new laws, for old cases, old laws. And that is really painful for all the functionaries because parallelly you have to see CRPC also, and then BNSS also, Indian Evidence Act also, and BSA also, depending on the cases when it started. When we look at this BNSS, see the name has changed. So from CRPC to Bharatiya Nagrik Suraksha Sanhita. So earlier they used the word code. Now it's more strict Sanhita instead of the code that what has been used. Chapter numbers are same. Earlier also it has 38 chapters. New law also has 38 chapters. So nothing to panic, nothing to say. Okay, some drastic changes are there. It's all manageable changes. We can understand what changes, and some changes are there which we have to look at. Earlier it was 528 sections, so total like 48 section number 484, but A, B, C, D. So 528 section was there. Now we have 533 sections. In the section 1, when they cross refer for the purpose of interpretations, so law always refer to IPC. Now it's referred to BNS, Bharatiya Suraksha, Nagrik Suraksha Sanhita. Okay, so some of the changes which are there in the law. There's a new definition which has been added. So audio, video, electronic, this word has been added. The idea being that this electronic change or digital change is the most crucial development which has been taken place by this new law. So new law permit that all proceeding, whether it's a summon trial, warrant trial, session trial, summary trial, statement recording by the police, statement recording by the magistrate, some kinds of inquiry done by the executive magistrate also, whatever the procedure we have seen in the CRPC, all those procedure when it's conducted under the BNSS, it can be conducted by audio video means. So a persons can give evidence from their own places or maybe respective places as the government may by rules specify. But there's a possibility. It's not that earlier it could not be possible. Earlier we know the changes were there earlier also. But now the manner in which it has put, so the entire thrust is that many things which we can manage online by video conferencing, you don't need to go to the court. So many public functionaries who has to come to the court for giving evidences. One very important provision with this change on the is when the public functions are involved, many witnesses who comes to the court, they are formal witnesses. So formal witness unnecessary, they have to make so much times and come to the court to give evidences. Sometimes they got transferred, they are located in some other places, again they have to come and give evidences. Now in the new law, they have provided the provisions where their successor can come and give evidences. The evidences can be by audio, video, electronic means. So they are very progressive provisions which will definitely going to help the judicial system in time management, saving the times of the persons who also go. Many times when go for evidences, it's got adjournment, so unnecessary there is a delay, etc. So all those suffering people will save from the new law. So that's a very positive sign of it when we look at it. So first changes on the definitions part, audio, video, electronic means they have defined. They mandate that all these proceedings can be conducted by audio, video, electronic means. They also have added first time the definition of bail. Now, bail definition was not there earlier. We know the bail implies the release of a person or submitting some surety or some bond. So people interpret cases, normally interpret what does bail imply. So bail only implies releasing of a person on bond. So when we teach the students in a law college, normally we teach in that way. Now that thing has been incorporated in the statutory provisions. So they define bail, they define bail bond also. So these are the new definitions which they have added. So bail definitions, bail bond definitions, electronic communications definitions, investigations, they have added, and explanations also will come to these definitions also. So when we look at the definitions part, there are some improvements, some changes which are there in the section 2 definition itself. So let's see audio video electronic means. When it defined audio video electronic means, this is the definition which has been given. So audio video electronic means shall include use of any communication device for the purpose of video conferencing, recording of processes of identification, search and seizure of evidence, transmission of electronic communications, and for such other purposes and for such other means as the state government may by rules provide. So many things which can be done by the audio video electronic means. Another very significant change which are there in this CRPC is the search and seizure procedure. So in the search and seizure procedure, entire search and seizure has to be videographed. It should be parallelly by audio video electronic means. And it says preferably by mobile. So like any search team can go, when they go to the scene of crime, they can start the videography, etc. So those days gone, when police will do search in one place and prepare the seizure list in Thana, and they will call someone to become witnesses, those days end. So now they have to, with preparations, they have to go to scene of crime. When they are doing to for search, they have to do the search. It has to be under videography. Might be, we don't know, tomorrow might be some rules may prescribe. Nowadays technology permit, if the videographies are taking there, if the video is recording, parallelly in the videos they will earmark the location. So video will specifically say where it was videographed. So might be by rule it will say, technology has make those mandated. When we, as a university teacher, when we submit report to NAC or something, we have to submit a photographs which having a locations mark. So that mobile phone technology allow that when you open the location will come to video or audio or maybe even to the photographs. So it is going to be much more scientifically foolproof system. So for the citizen, that's why we say it's a much more citizen centric. Many ill procedures or some kinds of some places, not I'm saying all places, but many ill practices were there. It will bring an end to automatically by virtue of law those ill practices in any part of the country. So it's a very progressive provisions from the point of view of the citizens. So audio video electronic means it has defined bail. We know this definition, like definition was not there, but we normally imply bail means release of a person accused of or suspected of a commission of an offense from the custody of lawful upon certain conditions imposed by an officer or the court on executing by such person of a bond or bail bond. So it basically, when they release, the authority which release, they may give conditions, etc. Normally in every bill there are some conditions. If nothing else, then at least the conditions to appear before the appropriate authority on time to time whenever this is called. So there is every bill, these conditions are always there, whether some person is released by the police or released by the judiciary. So in both cases, those are there. So they have defined bail. So it's only for the purpose of clarity. It brings some clarity in that regard. Bail bond means an undertaking for release with surety. Now we imply this, but again they have, just to bring some clarity, they have defined. So in the definition part, bond means a person's bond or an undertaking for release without surety. So it can be personal bond, it can be bond by the surety. Both ways the peoples are released from the court or system. So that's law permit. Investigation. Now same definition. There is no difference in the, so far the definition is concerned. Earlier it was 2H. Now investigation defined include all the proceeding under the Sanhita for the collection of evidences. So we know the investigation is for the purpose of collection of evidences by the police, which are other than the magistrate. So magistrate cannot do investigations, and that's why in the CRPC, when even the similar kinds of procedures, inquest, when executive magistrate do, we call it inquiry. When police do, we call it investigation. So because other than magistrate, they can do investigation, who is authorized by the magistrate in this behalf. Now, what's the change? The change is this explanation. Now, even if this explanation was not there, we always know that when there is a conflict between general law and special law always prevail. That's the basic principles of the interpretations, that special law prevail over the general law. So that thing they have clarified in this explanation. So one explanation has been added in this investigation definitions, that where any of the provision of special acts are inconsistent with the provision of the Sanhita, the provision of special act shall prevail. So we know there are many special laws, and accordingly those special laws, special provisions can be that prevail over this law. So these are the changes which we see in the definitions part. Many changes a law could have brought further, but which have not been brought in the law. They have done some changes in respect of victim rights. For instance, one of the obligations under the new law is that within 90 days of the cases, the police has to inform the development of the investigations to the victim or informant. So those who are given information, very positive things. But when we see from the victim point of view or victim rights point of view, in my view, in present day, the two laws which basically can create a benchmark for the victim rights. One is at SCSC Atrocities Act 2015 amendment. Excellent provisions for the victim rights. Why can't those provisions can also be included for the other victims? So those provisions could have been incorporated in the CRPC. That gap is still there. Similarly, in POCSO, the kinds of protection which are there for the sexual offense victims is enormous, excellent protections. Some of the things that could also be applicable could have been brought in the CRPC. But some changes are there from the victim rights point of view, because right to information, to get that what the progress in the cases are there, victims are never considered or rarely considered as a stakeholder. But in reality, they are the main stakeholder. Why police doing investigation? Because there is a victim whose rights are violated. Why prosecutor doing trial? Because some victims are there whose rights are violated, and accordingly we are doing the trial, and the judge also do the same thing. So victim should be ideally in any justice system should be a central point, but somehow we don't give him that treatment to the victims in our adversarial system. So that's investigation definition they have done. Chapter 2, Constitution of the Criminal Court. Now, two things. One, first, metropolitan area in Odisha. I don't, there's a metropolitan court here. But those places who feel themselves that they are superior, they have metropolitan magistrate court, Calcutta, Bombay, Chennai, etc. Now that gone. So there's nothing called metropolitan magistrate. So all are judicial magistrate first class throughout the country. So the concept of metropolitan magistrates are omitted from the new law. So metropolitan magistrate courts will not be there. So second, among the session judge, in the first schedule, when we look at the CRPC, when it says which court will conduct the trial, last part, last column, it did not say assistant session judge, it says session court. And we so know the session court includes session judge and assistant session judge. So session judge, additional session judge, same power, and the assistant session judge having the lesser power because their powers are less than this session court. That's what the CRPC has says. Now again, that court also gone. So there is no concept of assistant session judge. So two categories of court. Assistant session judge must be here also. In all places there is assistant session judge court. So under the new hierarchy of the criminal court, the assistant session judge court will be removed. It's not going to be there. So you have a judicial magistrate court, and then you have a session court. So among session judge, the second hierarchy, assistant session judge court, that is going to be removed under the new law. It's abolished. This entire rank is being abolished. So there is nothing called the assistant session court. Only difficulty comes that most of the places, those who are assistant session judge, like in West Bengal, they have a dual role. So they deal with the civil cases, they deal with the criminal cases. So when they deal with the criminal cases, they are assistant session judge, and deal civil cases, they are civil judge senior division. In Bengal, there are other places also the same thing. I don't know about Odisha. So same system. So accordingly, now CPC has not changed. So civil judge senior division will remain there. That's not going to be changed. So now they are getting with the exclusive power of the civil courts now. The civil judges there. For public prosecutor, there is a similar provisions. Some minor changes are there in the public prosecutor provision. We look into that public prosecutor provision. So earlier it was section 24. So now in the new law it is section 18. So earlier 24, then 25, then 25A. So 18, 19, 20. So the chronologically is the same. The number is being changed. One proviso has been added in clause 1, first clause itself. It was exclusively for Delhi. I think just to settle the issues that there's always tussle between the Delhi government and the central government. So proviso says that so far Delhi is concerned, the central government shall appoint the public prosecutor. So that's the one proviso has been added in the first part of it. Other part by and large remains same. Some changes are there which we see. For instance, if you remember the clause 6 of section 24. In the clause 6 where they says that in a state where we have a cadre of prosecutors, the public prosecutor shall be appointed from that cadre. So what shall is there in section 24 clause 6, and most of the states in the country has made amendment in clause 6. Probably Odisha also, West Bengal also, they all had made amendment in clause 6. Some places shall word change to may. Some places says unless there is no competent person. So there's a different ways. The different state amendment they have made in respect of the clause 6. Now that clause 6 has made changes, and it has added a proviso. First part is shall, and then added the proviso unless the state government consider that no competent person etc. are available in the panel who can be appointed as a public prosecutor. So just to keep, then in those circumstances from the panel they will appoint the public prosecutor. So that's the changes are there in section 24. So new provision in section 20. These are another changes. So 20 is about the which was section 25A, Directorate of Public Prosecution. Now this is again very progressive changes in 25A. The 25A, when it was incorporated in 2005, the idea was that among the prosecuting agencies, there is some gap exists in respect of some developing accountability system, reporting system, coordination between the different functionaries like police and prosecutors. So a whole idea was there will be a Directorate of Prosecutions at the district level, Deputy Director of Prosecutions, and they will act as a coordinating body. So there will be coordination between the police and the prosecutor. So that gap which exists, that gap can be filled by this Directorate of Prosecutions. Many places that point of time the Directorate of Prosecution was established with enthusiasm. Some districts they have established. In West Bengal initially they established in around 5-6 districts or 4 districts, and gradually now only on paper. There is only one Director of Prosecution who are there at the state level. Now to boost it in 25A, which will become section 20, is a very progressive provisions where not only talk about the Directorate of Prosecution at the state level, but also it has incorporated the system of the district Directorate of Prosecution. So which were established by the state government at the every district. So now legally we have a mandatory provisions for the state government to establish district Directorate of Prosecutions, and definitely it is a welcome provisions because it will improve in the bringing some kinds of accountability, functioning, reporting systems, coordination with the police, or even other systems in the prosecution department. So those changes has been brought there, and they laid down the qualifications, etc., which were by and large the similar to the earlier provision which are there. So they have added deputy director of prosecution. So at the state level, we have director of prosecution. At the district level, we have a deputy director of prosecutions will be established under this new law. And so that's basically a very progressive provisions. It's laid down the responsibility of them and under those clauses. We look into this. So let me see some changes which are there. So in that, before that part only, so after the constitution of the court and then comes the executive magistrate. Earlier it was executive magistrate was 20 and 21. 20 executive magistrate, 21 was special executive magistrate. In the old CRPC, special executive magistrate was provision was for giving special power to certain executive magistrate, and in exercise of that power, some of the states in the country has given some judicial functions in even power to take cognizance in smaller offenses, petty offenses, etc. So that special power was given there. Now, under the new law, when we talk about the special executive magistrate, it is completely different thing, not what was there earlier in 21. It is a different thing is that under 15, when they say special executive magistrate, they empowered the government to appoint superintendent of police as an special executive magistrate for the district. This is again new thing. In the earlier system, under section 20 clause 5, the government can empower the commissioner of police to act as an executive magistrate, and many places in the country the commissioner of police has been declared as an executive magistrate, but there was no provisions in respect of giving the power of executive magistrate to superintendent of police, to SP. So that also one of the commissionerate is a little hierarchy, then the SP structures, etc. That has been dismantled now. So even the government can give power of special executive magistrate to the superintendent of police also. So the state government may appoint for such term as it may think fit executive magistrate or any public officer not below the rank of superintendent of police or equivalent to be known as special executive magistrate for particular areas or for the performance of particular functions, and confer on such a special executive magistrate such of the powers as are conferable under the Sanhita on executive magistrate as it may think fit. Remember, there are many laws, special laws, where the executive magistrate has some kinds of a role. Essential Commodities Act, they have some kinds of a role. Your Immoral Trafficking Prevention Act, under section 18, the executive magistrate can pass the order for closure of a brothels, etc. So very enormous power, very important power under the act, which could be utilized. So now that powers can be vested to the SP under this provision. So this again is a welcome provision, we can say, that the special executive magistrate powers can be given to the SP. Section 20, Directorate of Prosecutions, which we just discussed. So 21B of the BNSS has inserted to introduce the district directorate of prosecution in every district. So as we discussed, in every district there will be district directorate of prosecution. Much detailed provisions on the directorate of prosecution. So very detailed, it has laid down the provisions in respect of the directorate of prosecutions. Let me just quickly, because these all powers are in respect of your functioning. Let me quickly see the provision. Yeah, so 18 talk about the public prosecutor. If you see the first part, language is same what was there earlier. For every high court, the central government or the state government shall, after consultation with the high court, appoint a public prosecutor and may also appoint one or more additional public prosecutor for conducting in such case any prosecution, appeal or other proceeding on behalf of the central government or the state government as may case may be. So this was the same what was there in 24 clause 1. This proviso has been added, and so provided that this is the new provision which they have added. National Territory of Delhi, the central government shall, after consultation with the High Court of Delhi, appoint the public prosecutor or additional public prosecutor for the purpose of this section. So just to end this all the tussle from the Delhi government and the central government, they wanted to make clear that the public prosecutor they can appoint. Clause 2, the central government may appoint one more public prosecutor for the purpose of conducting the cases in district or local area. It was also there earlier. For every district, state government also in the same way provided. That was earlier also. Provided that the public prosecutor, additional public prosecutor for one district may be appointed, they can act for the other district. It was earlier also. Clause 4, the district magistrate shall, in consultation with the session judge, prepare a final of names of persons who are in opinion to be fit to be appointed as public prosecutor, additional public prosecutor for the district. Now, this is the common procedure, same was earlier also. So, DM prepared the panel as we can panel public prosecutors and with the consultation of the session judge. Clause 5, no person shall be appointed by the state government as public prosecutor, additional public prosecutor for the district unless his name appear in the panel prepared by the district magistrate under subsection 4. So that's the general procedure. Now clause 6 was in very important power which was there earlier. Same language is here. So notwithstanding anything contained in clause 5, when a state there exists a regular cadre of prosecuting officer, the state government shall appoint a public prosecutor or an additional public prosecutor only from the among the persons constituting such cadre. Now this provision was earlier also, clause 6. And this provision was amended by almost every state because so that they can appoint the public prosecutor from the panel. Now, considering that because the state has made amendment all the state, this time apart this provision was not there in section 24. This new provision has been added there, and this provision says provided that where in the opinion of the state government no suitable person is available in such cadre for such appointment, that the state government may appoint a person of public prosecutor or additional public prosecutor as the case may be from the panel name prepared by the district magistrate. So just to clarify, just to give some margin to the state that if they want, they can appoint the public prosecutor from the panel. This provision was being added. And then 7, 8, 9 is the similar provision what was there earlier. It's the same thing which they have carried in the public prosecutor. Now, assistant public prosecutor, similar provision which are there. So, state government shall appoint in every district one or more public assistant public prosecutor for conducting prosecution in the court of magistrate. The central government may appoint assistant public prosecutor without prejudice to the provision contained in subsection 1 and 2, where no assistant public prosecutor is available for the purpose of any particular case. The DM may appoint any other person as assistant public prosecutor. It was there earlier also. This provision was also earlier there, provided that no police officer shall be eligible to appointed as an assistant public prosecutor if he has taken part in investigations and below the rank of inspector. Now, this was also there in the old law. It was there in old law, but that point of time when this provision came, it has an objectives. The objective was we have just transition in 73. So before 1973 legislations, there was a police prosecutor or there is a inspector who is prosecuting inspector who prosecute in the court. So when the new system came, they keep this margin that in some cases where nothing is available, they can continue for some time. But from 73 to 2024, now I don't think anywhere in the country we have a system where the police is involved in the prosecuting, because we have an effective cadre throughout the country. So per se, this proviso does not require at this point of time. It might be necessary that time when you do transition. The transition phase is over long ago. So 73, now 2024. But it never, whatever it may be, they have added these provisions here. But in any case, I don't think there is any places they are going to implement or appoint any police officers for the purpose of prosecuting, bar will call strike that local bar immediately. So we'll not having, probably it will not have implemented in any places now. Director of Prosecutions, which was 25A, very important provisions. I think throughout the globe, almost every developed world countries, they have these kinds of mechanisms where there's a some kinds of structure of the prosecuting agencies. There are reporting systems where the prosecutor has a report to submit their feedback, reporting on the acquittals, etc., whatever it may be. So, or if there is a need for some kind of support, there must be some persons who can bring their case forward to others. So, A, Directorate of Prosecutions in state consisting of Director of Prosecutions and as many Deputy Director of Prosecution as you think fit. So at the state level, there will be Director of Prosecutions and as many Deputy Director government want, they can appoint. B, here one more changes is there. Earlier, when we see the qualification of Director of Prosecutions, it was not very clear because there are many places in the initial age when the act was came. Police officers were appointed Director of Prosecution. There are cases happened in few courts, high courts, and the later was changed. Like in West Bengal, first Director of Prosecution was Nazrul Islam, IPS officer, and then immediately it was changed, and then one from the prosecuting one person becomes Director of Prosecution in West Bengal. It's happened in several other places also. Now, what the idea is that this director or deputy director, it can be either the advocate, which include prosecutors also, or can be from judiciary. So, for Director of Prosecution, it says it can be from the rank of the district judges or session judges. For the deputy director, it can be from the rank of judicial magistrate. So, what from the language is inspire or what transpire basically, that might be the government has this thing in mind that tomorrow for the Director of Prosecution or Deputy Director of Prosecution or at the district level, might be they will start a system where by deputation they will appoint from the judiciary also as a director or deputy director, because when you see the qualifications which was not there earlier. So A, the Director of Prosecution in the state consisting of director and as many deputy director. B, a district Directorate of Prosecution in every district consisting of as many deputy director and assistant director of prosecution. So implies that district Director of Prosecutions, the head will be deputy director and there will be assistant director there. Who will be a person eligible? A person shall be eligible to be appointed A, as a Director of Prosecution or Deputy Director of Prosecution, he has been in the practice as an advocate for not less than 15 years or has been a session judge. So, when we say 15 years, it definitely includes the prosecutors also, which is basically that's also counted as an advocate. So, it can be either prosecutor or any advocate who can be appointed having 15 years of experience as director, or person will having the post of the district judge. Assistant Director of Prosecution practice as an advocate not less than 7 years or has been magistrate of the first class. So, that was not there earlier. So, my guess is that might be something in pipeline that in some places might be by deputation from the judiciary. This post might also be filled up. 4, every deputy director of prosecution or assistant director of prosecution shall be subordinate to director of prosecution. The similar language was earlier there. Every public prosecutor, additional public prosecutor, special public prosecutor appointed by the state government under subsection 1 or subsection 8 of 18 to be conducted cases in High Court shall be subordinate to Director of Prosecution. So, High Court level, they will directly under the Director of Prosecution. Every public prosecutor, additional public prosecutor, special public prosecutor appointed by the state under subsection 3 or subsection 8 of 18 to conduct cases in the district, and every assistant public prosecutor appointed in subsection 1 of 19 shall be subordinate to deputy director or assistant director of the prosecution, so district Directorate of Prosecution. The power and function of the Director of Prosecution shall be monitor cases in which offences are punishable for 10 years or more, or with fine, imprisonment, or with death, to expedite the proceedings and give opinion, filing an appeal. The power and function of the Deputy Director of Prosecution shall be to examine and scrutinize the police report and monitor the cases in which the offence is punishable for 7 years or more, but less than 10 years, for ensuring that they are expeditious. The functions of here, when it says now these are the provisions. Many times when we make the provisions, that very high rank officer we interested with, that all the cases where the punishment is above 10 years, it will do by the director. For director himself is not possible, humanly not possible. The state is too big. So many times it's become challenge. They could have added deputy director here. Here deputy director will do 7 years to 10 years. Assistant director less than 7 years. And then the notwithstanding anything contained in subsection 7, 8, 9, the deputy director, assistant director of prosecution shall have the power to deal with and be responsible for all proceeding under the Sanhita. The other power and function of director, deputy director, and assistant director of prosecutions, and the areas for which each of the director of prosecution or assistant director of prosecution has been appointed shall be such as the state government may notify and specify. The provision of this section shall not apply to the Advocate General for the state while performing function as a public prosecutor. So that basically the provision which was there in respect of the Directorate of Prosecution. So that's the chapters on the prosecutions. Next chapter is there, which we say the power of court, the same kinds of power which was there. Only thing is section 27 was rightly omitted. 27 was in respect of juvenile, because now the juvenile it was redundant. There is no use of that provision, so juvenile will automatically go to the JJB. So there no point in keeping that in the BNSS. Remove mention of assistant session judge, metropolitan magistrate. I said already, these two kinds of courts no more will exist under this law. Old cases will continue, but new cases will not be there before this court. Chapter 4, power of the superior officers and police, aid to magistrate and the police. There is no changes, the same provision what was there earlier, the same thing are there. 30, earlier it was 35, 36, 37, those sections were there. So now 32, 34, power of the police, etc. are completely unchanged. There is no changes in that power. Arrest. When we look at the arrest provisions, we all know earlier section 41 with the power of arrest, and 41A, which added the provisions, classify the offences where the punishment is 7 years above and up to 7 years in two circumstances, and they laid down the different ways in which to deal with these two categories of offences. In the new law BNSS, what they did is they merged both the sections. So what was 40 and 41A, both combined now become section 35. So what was 40 and 41A become 35. Same thing is there. So you don't find the changes in the language. So like when 41A talk about up to 7 years, then qualifications, that they must believe that the person has committed offense, and then some other requirement which are there. The same requirements are there in the new law, where the punishment is more than 7 years, so their personal belief, and then they can arrest. So that's same thing are there in the 35. So what was 40 and 41 and 41A, that becomes section 35 under the new act. So incorporated 41A in 41, that is 35. Compassionate grant permission of DSP to arrest in infirm of 60 for the offences under 3 years imprisonment. So in some cases where the punishment is only up to 3 years and the person is above 60 years, senior citizens, etc. Before arresting them, permission from the DSP superior officer police has to take. So that check is there. We look into section in great detail. Another changes which are there in the arrest provision is which was earlier 41C. So there is a system that there will be control room where all the information of arrest will go. The control room will publish the data of the arrest in the districts, etc. What the new law emphasizes is that at the police station level, there will be one designated officer not below the rank of ASI, assistant sub inspector. So so it can be SI also. It's not below the rank of ASI that is written. So that designated officer will keep and maintain the data of all arrests at the police station level, and they will upload the information as per the rules prescribed. So it can be by the board, it can be by website. So nowadays everything will go electronically. So they will be responsible for giving, disseminating information of all the arrests at the district level. Same time, one designated person will be at the district level, and within the SP office, one designated person will be responsible for it, who will collate our information. So all these designated officers of the police station will pass on the information to that designated persons at the district level, and that will upload the informations on day-to-day basis in the website or other places as the rule prescribed. So government will bring the ways in which it can be uploaded. So whole idea was that at the police station level, one person will upload the informations or disseminate informations. At the district level, one person will be responsible who will disseminate information of all the arrests in the district. So that concept of was a control room that has been changed. So the same persons directed to display on notice board outside the district control room name, address of the arrested person, designation of the arresting corps who arrested, state police headquarters to maintain the database of arrest, name, offense for information to the public. Now specific responsibility on the police officer. So there will be designated police officer in every district and every police station not below the rank of ASI to maintain the information about the persons arrested, name, address, and offense. So the idea is that there must be some accountability system. So when you have a designated person, if the information is not given, then he is responsible for their violations. Detail to be prominent display in any mode, including digital, in every PS and the district headquarters. Specific responsibility, nature of the offense, PS level, digital mode. So removals, database of the headquarter, obligation of the control room to display no information about the arresting cops. So it was earlier, so now it has been added there. So arrest of the persons. Now another changes in arrest. We know earlier there was section 43. In the CRPC, 43 was the only section in the CRPC where the word rearrest was used. So any private persons can arrest, bring the persons to the police, police will do rearrest. So that's the word they have been used. Now they have changed the word rearrest from rearrest to shall take him in custody. So they use the word custody. For practical purposes, there is no changes. Probably the idea is that you can't arrest twice a person. The issue will come when police is taking in custody, then police has to prepare the arrest memo. Police has to give information to the family members, their relatives. So what time the arrest will be shown? No, not written there. In my view, it will be the time when police take into custody. It cannot be, police cannot write something the earlier time when the private person has done. Now, what time will be counted for the purpose of 24 hours? Again, nothing has been said. But in my view, for 24 hours, it should be counted from the time when the accused being arrested by the private person. If it is the right arrest, it should count from there. But arrest memo, it should be time when the police got custody of it. That's my view, because that's the best way in which we can interpret the provisions. Accused right need to be recognized, because the time when they are in custody, that custody has to be recognized. For police, they cannot write something custody when they are beyond their custody. They have to write on the time when they got the custody of the person. So that 43 become 40 now, and in 40 this changes, rearrest word has been changed to shall take him in custody. And when they take him in custody, all formalities are there. The same language was earlier. So before taking him into custody, before rearrest, earlier it was says that the police will check whether it satisfies the requirement, because he really committed cognizable offenses, they are eligible to commit. Now they have added these all safeguard which are there in 35. So 41 safeguard also added. So whether they have a power to arrest as per section 35, if they have power to arrest, then they can take him into custody. If not, then they can release after taking bond. Now, how arrest made? There is some changes here also. Now, I was expecting more changes in this how arrest made. Providing information to relatives, friends, or any other persons disclosed by her about the place being held. That's the good provision they have added, how arrest made. So the female member, they have also added a female can be only arrested by the female. The same principles earlier which was there, that from sunset to sunrise, a female cannot be arrested, and when they consider it is very necessary, it should be women. They must take prior permission from the judicial magistrate. I don't know, no law is there. They could have changed it to executive magistrate. Getting judicial magistrate in the night, I don't know what the structures available. My experience in West Bengal, we don't have any like structure which available that district just say, okay, in this division, this magistrate is available 24/7. You can go and get report. I don't think those structure is there. If executive magistrate, they are more accessible. They can easily access. So safeguard is required, undoubtedly. We are not saying that there should not be safeguard for a women, but safeguard will be such which could not become detrimental for the police also. So that's the changes has been there. Handcuffing, we all know Sunil Batra and other judgment where Supreme Court says it's a violating of the rights of the citizens. When we do handcuff, it's so human rights, everyone has the right to privacy. They are all, we have to presume them innocent till proven guilty. So why to handcuff, etc. Now, so handcuffing, which was stopped at point of time, again it is reintroduced, handcuffing here in 43 clause 3, but it reintroduced only in the grievous offenses, serious offenses. So it has enlisted the kinds of offenses where the police can do handcuffing. So the police officers may, keeping in view the nature and gravity of the offense, use handcuff while effecting the arrest of the person who is a habitual repeat offender or who escaped from custody, who has committed offense of organized crime, offense of terrorist act, drug-related crime, or offense of illegal possession of arms and ammunition, murder, rape, acid attack, counterfeit of coin, currency notes, human trafficking, sexual offenses against children, offenses against the state, including acts endangering sovereignty, unity, and integrity of India, or economic offenses. So even they enlisted, but the list is not very small. It's a bigger list. So many offenses can be covered under which where they can do handcuffing. So they have added nothing to be critical of it. This is fair provisions. I don't know when this handcuffing was not there. Many places the police use that what's rassi. So all 8 people, 10 people are bound with different rassi. It is more dehumanizing. Then the handcuffing, at least handcuffing is alone. Or maybe he can, if there's a longer cloth, it will not show with the police he's going with the handcuffing. But if there's a rassi and 18 people are there, it's happening in many places in the country. So yes, that provision has been added, and it's not we are doing throughout the world. Police department, they use handcuffing for the purpose of offenses. So yes, that new additions or reintroduction of the handcuffing in the specific cases they have started. Okay. Obligations of the person making arrest to inform about the arrest, etc., to nominated person. It was there earlier in 50A, now become 48. Addition is information about the arrest must be given to designated police officer in the district 2, which I said that every police station level there will be one designated officer, and at the district level there will be one designated officer. So when the police station level designated officer should inform the district level designated officer so that he can upload the information at the district level. So that's a reasonable good provisions. Power to seize offensive weapon, which was earlier section 52. Remember 51 says a power of search of arrested person. So when a person is arrested, they can be searched. 52 says if some weapon is being found, they can be seized under 52. So that become 50. Now only change is there is immediately after arrest is made, that what has been added. Earlier this what was not there. So earlier it was there. After arrest is months, if the during the search, if the arms ammunition were found, they can be seized. So this says immediately after arrest is made. So it gives some clarity. In any case, the seizure or search comes only after arrest only. So when they arrest, they do. It's not that they are doing search arrest now and do search after 2-3 hours. It happened the same time only. So they have thus clarified it that immediately after arrest is made. Okay, this is a very significant change and it's a good provisions on medical examinations. All the 3 places where we see the medical examinations, earlier 53, 53A, 164A, 164A for victim, 53A for accused, 53 again for the accused, where the police normally said for the medical examination. In all these 3 places, they have made changes. Specific changes is these are additional obligations on the registered medical practitioner to send the request report at the earliest. So that's a positive obligation. So in 2 places they use the word, the registered medical personnel shall without any delay, that's the word is there, shall without any delay forward the examinations report to the investigating officer, and then investigating officer will send the report to the court. So that's a very positive sign, because many places the medical fraternity or the hospital take longer time to send the report. So at least this is a very positive thing. In fact, in these 2 places, it says without any delay. The section which was 164A, rape victims medical examinations, there it is says the send the report within 7 days. So they fix the 7 days timeline. Another changes is there, if the medical examination is of the women, the medical examination shall be conducted by a female medical registered practitioner or a medical officer, or in the presence of female medical officer, the examinations can be conducted. In the absence of female medical officer, any other female registered medical practitioner. That's again very progressive provision, because I know many cases when a women go for medical examinations, there are cases where they refuse only because there's a male doctor who wanted to do medical examination. So now again, this the government has to come up with the manpower. So it's the hospital's duty to have more female doctors, so that for the medical examinations can be done by the female in respect of the victim or even the accused. So these changes are 53 and 53A. Both places they changes in respect of the without any delay, they have to send the medical report. Registered medical practitioners, this says implies anyone who was registered under the National Medical Commissions Act 2019. So basically all MBBS doctors, they are all registered medical practitioners. They can do medical examinations. So again, it make possible that in cases where the female doctors are not available, medical officers are not available, it can be done by the other medical registered medical practitioner, female registered medical practitioner. So again, it's a very progressive provision. Examinations of the arrested person by the medical officers, which was earlier 54, now become 53. It's added on a proviso, and proviso says, provided that where the arrested, which I said earlier, arrested person is a female, the examination of the body shall be made only by or under the supervision of a female medical officer. And in case the female medical officer is not available, by a female registered medical practitioner. Provided further that if the registered medical practitioner is the opinion that one more examination of such person is necessary, she may do so. So the registered medical practitioner can give opinion that okay, again the persons can be brought for medical examination. 54A, which was added earlier, now becomes section 54. It's basically TI parade. In the CRPC, we don't had for a long time, we don't have provision for TI parade. TI parade is always being conducted as because it's relevant under Section 9 of Indian Evidence Act. But CRPC, they added just few years ago, 54A. Now, only change they have done is that this identification process shall be recorded by any audio, video, electronic means. That again, very progressive provisions. Now, the technologies are available. It's easier to record everything. Why can't we have this audio, video, electronic means? Person arrested not to be detained more than 24 hours. Clarified, it's the same thing. Earlier also the same thing happened. So when a person has to produce either before the magistrate where the case is going to be committed for trial, or it can be other places when they go to arrest in some outside jurisdictions. So any near magistrate they produce. So they have clarified to magistrate court whether have jurisdictions or not. So the persons can be bring before any magistrate within 24 hours. The same practice was there. Just for clarity, they have added it. Practice was not different. So either they bring before the court where the trial will be conducted, or if it is outside the jurisdiction, then the local court there, and then transit remand, etc. That's the normal practice which the police do. Okay, so how arrest made? I said this provision, handcuffing, we have already read 43(1), arrest of the women, providing information to the relatives, friends, or other person disclosed by her about the place held where she was kept. That has to, information has to be given to the family members. Examination of the arrested person by medical officers, we just say, provide that where the arrested person is a female, the examination of the body shall be made by the only by the or under the supervision of the female medical officer. Person arrested not to be detained more than 24 hours. So magistrate court whether having jurisdictions or not. So the same practice was there. Earlier it was not mentioned. In arrest also, there is a one new concept which has been developed, and you must have seen the cases like Navlakha case, the Supreme Court judgment where the accused was kept in the house arrest. In Calcutta, also one case happened just a few months ago, where the accused was kept in the house arrest for some period of time. And in the Navlakha case, when initial period he was kept in the house arrest, the issue comes subsequently that whether the period when he was under the house arrest, whether that will be counted towards 167, because of the 60 or 90 days period, whether it will be counted or not. And Supreme Court categorically in that case says that no, it will not be counted. So it will not be counted within the determination of 60 days and 90 days. Now, house arrest has been used in few cases because there might be some possibility where we can use the house arrest provisions, but in the new law they have not used, they have not touched upon the anything on the house arrest. So it's do developed a year, maybe one and a half years ago, Navlakha case, in Calcutta case, but they have not used the word house arrest in the new arrest provision. So it's remain as it was earlier, the same thing which is there in this act. Okay, now we come to the chapter 6 on process to compel appearances. There is a few major changes which are there, and those major changes are every places nowadays it is being considered that all these summon etc. they all can be sent by electronic means. So by email summon can be sent, that is possible. And so the summon can be sent by email. So those kinds of changes are there. So that's impliedly that now the government has to make their own databases. When a person is arrested, there must be some form in which, apart from the name, address, email ID, phone number, etc., all those need to be maintained. so that the summon can be sent by the email, and that's the changes has been done. So a new form has been created, form number 63-2. Summon in encrypted or any other form of electronic communication bearing image and seal of the court. So that summon can be sent by email also. 64, summon has served. 64(1) says, provided that the police station or the registrar in the court shall maintain a register to enter the address, email, phone number, and such other details as the state government may by rules provide. So now we have come a time when in the court they have to maintain the registers, databases where with the email ID, and through email the summon will go. It's a good provisions, but still we are not throughout the country. The villagers, how many of people who are of age really use this mechanism? Young people can use, but the others there's a difficulty. So now it is supplementary, it's not mandatory. It's in addition to the other summon, it can be by the email can be given. 64(2), provided that the summon bearing the image of the court seal may also be served by electronic communication in such form and in such manner as the state government may by rules prescribe. So the state government will prescribe the rule in the manner in which the email can be sent. So summon can be sent by email under the new law, that is possible. So that's positive sign. Service of summon on corporate bodies, 65. Now the ambit has little bit expanded. So earlier it used the word secretary, local manager, principal officer. Now they use the word director, manager, secretary, or other officers of the company or corporation. So it's a very broad word. By using the word other officers, anyone who is in charge of that particular branch, etc., the service to the companies can be served under this law. So it's a positive thing. 65(2), service on the firms and association of individuals is laid down in the same way. Proof of service, 73. All summons served through electronic communication under 64 to 71 shall be considered as duly served, and a copy of such service electronic summon shall be attested and kept as a proof of service of summon. So now if the service of summon is done by the electronic means, by electronic way, that will also is a proof of the fact that the service of summon is being served, duly served. Okay, 66. There's a minor change, but it's a progressive change. Earlier, when the provision was there, when the police went to serve a summon in a home, and the person is not found, the police can serve the summon to any adult male member. That is what was there. That make the gender neutral. So any person in the home, the summon can be served. So it's very progressive provision. We cannot have only adult male member. Most of the time in the home, the females are there. So that changes has been made. Warrant of arrest and then proclamation. Now, there are changes, some of the changes which are there in the arrest and proclamation provisions. There are very progressive provisions are there on the property confiscation of the persons who are not being found or who are proclaimed offender. So 82, clause 2, procedure on arrest of the person against whom warrant issued. On arrest of any persons referred to in subsection 1, the police officer shall forthwith give the information regarding such arrest and the place where the arrest person is being held to the designated police officer in the district and such officer of another district where the arrested persons normally reside. So when the arrest by warrant has been done outside the local area, then the arrested police officer, designated police officer who is maintaining the data in the police station has to give information in 2 districts. The district where the arrest is being made and the local district of the person being arrested. So both places the information has to go. So again, it's a positive provisions. Now proclamation and attachment, 84, clause 4, proclamation for persons absconding. So the proclamation is with respect to the persons accused of an offence and with 10 years imprisonment or more, and persons fail to appear, the court may pronounce them as proclaimed offender. So earlier they used the IPC provisions, now they the another act, etc. 86, its mandate for identification and attachment of the property of proclaimed person. So the court may, on written request from the police officers not below the rank of superintendent of police or commissioner of police, initiate the process of requesting assistance from the court or authority in the contracting state for identification, attachment, and forfeiture of the property belonging to proclaimed persons in accordance with the procedure provided in Chapter 8. So when there is a bilateral treaty between other countries, foreign countries, in those circumstances, if the person is proclaimed offender, in the treaty countries, the request can be sent to their local court according to rules for identification and attachment of the property. So the Indian court can also start the process for attachment of the property. The property of the person is outside India. That's again progressive provisions when we say under the law. So where the attachment can be done, and we know the many cases which are there where the persons are outside the country. So 86 says, which we just read. So under Chapter 8, it's laid down the process for identification. So contracting state for identification, attachment, and forfeiture of the property belonging to a proclaimed persons in accordance with the procedure provided in Chapter 8. So that again, the property can be attached if it is in the any contracting country. So for India, Nepal, Bangladesh, there are many countries with which Sri Lanka, there are many countries with we have some bilateral treaty. In the international law or the international instrument, we sometimes call it MLA, Mutual Legal Assistance Treaty. So where many countries has a bilateral treaty for MLA provisions, where one country will assist the other country in investigations, collection of evidences, recording of the statements, etc., identification of the property, search and seizure. So all this mutual legal assistance agreement of the both the countries will decide how this process of within the criminal justice systems can be conducted. Okay. Now we come to so now you think about the chapter like in the CRPC in the same way the new act is. So you have a one chapter on the summon. So summon to the persons, then warrant. Warrant can be on persons, on the production of things, goods, so two kinds of those there. And thereafter the provisions comes in respect of a process to compel the production of a thing. So how we can compel someone to produce something? Again, there's a very important new section has been added here, which was not there earlier. Now, 105, we look into little detail 105, completely new provision. 105 talk about the search and seizure, which need to be conducted by audio, video, electronic means. So when the search and seizure is conducted, that point of time they have to from the beginning they have to do this audio video means they will start it. So under this chapter or under section 86, when we say under this chapter implies when we are doing with search with warrant. 186 is the same provision which we have seen earlier, 165. So 165 police can do search without warrant. So 165 is 186. 166 is 187. I don't know when they use the 186 why they have not used 187. The same thing. When they do, police can do search outside their jurisdictions under 186, and if they do outside the jurisdiction under 187. So the both principle will apply. Preferably through cell phone, police officers shall forward without delay to SDM, Judicial Magistrate First Class. 187 is another very powerful provisions when we see in respect of attachment, feature, registration of the property. So an extensive provisions for the attachment. I think this is again the new thing in our judicial system. We may remember during our political campaign in this election, one day the Prime Minister make a speech that we are going to make a systems where the property of the criminals which will be attached, they will be distributed among victims. So from where they got the property. So the criminal's property, they will be seized and they will be distributed to the victims in one place. Some places he make his speech. I was just remember sometime. Probably it is 107. It's a complete new thing has been introduced, and we look into 107 in very great detail. It's a complete new things where a property which are proceed of crimes, if it is confiscated, seized, and if the court consider this is an proceed of crimes, the court will ask the district magistrate to distribute this property. They have used the word ratably. When sometimes we say proportionately, sometimes say appropriately. They have used in the section, they have used the word ratably, implies whatever the rate their losses are, accordingly whatever money is being found, that can be distributed among those victims. And if no victim is found, or if there is surplus money, that will go to state exchequer. So so many times it will go to state exchequer only, all these proceed of crime. So this is one provisions which make possible where the property of the offenders which are proceed of crimes, if it is proved, then they can be distributed to the victims, and that become possible because of 106. We'll look into it. Now let's see 105. And this is the provision really challenging for the police officers. So any training, number of training I have done, so they are more concerned with these provisions. 105. So 105 says, but it is very good for the citizen of this country. So entire argument of not being searched, never been to places, search other places, all those in the cross-examination when the defense lawyer asks, so without going to the place, you have not done search, you prepared every seizure list in the police station, all those cross-examinations the defense asks, those days gone. Now every search has to be video, audio, video, electronic means they have to use when the search is started. So 105 what it says, and then we'll go for tea break. 105 says recording of the search and seizure through audio, video, electronic means. The process of conducting search of a place or taking possession of any property, article or thing under this chapter or under section 85. What is 85? 85 I said already, it is previous say 165. Including, so but they could have added 186 also, because 165 out of 165 we have 166. So same thing is 186. 186 that could have been used. Including preparation of list of all things seized in the course of such search and seizure, and signing of such list by witnesses shall be recorded through any audio, video, electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, sub-divisional magistrate, or judicial magistrate first class. So now it's become mandatory for any search and seizure when it is conducted, from the beginning of the starting of the search point till the end, including that filling of the form, signing of the form by two witnesses, all has to be done in the during that videography or audiography, etc., that point of time. So it is really making some foolproof systems. Definitely for the prosecutor, it will become much easier for proving the cases. If many witnesses, when they come and turn hostile, had the police used the earlier power, under the 161, they have a power to record the statement by audio video means. How many cases they do? They rarely. When some system is not working, or some system where we can change, we find some convenience way, we do that. So even though amendment was there, but I don't find really police officer using that provision. 161 was amended, 164 was amended, but they don't do. Had they used that provisions, the chances of witness turning hostile will minimize. Because as soon as the witness know that when I give any statement, my entire statement is videograph, it's a human psychology. There is a rare chances that he will come and change the view. The language may change, but the content on specific things will not be changed. Now, at least it's good provisions. It can be search and seizure when it is being conducted by videograph. there's a more chances that it's a search and seizure, there's a less issue will arises in respect of reliability. Many times the reliability decreases on the search and seizures, so that chances will reduce, and it will also protect the citizen also from unwanted, if there is some kinds of ill practices, so that practices will go. That practice will not be there now, so it will be completely foolproof, a better system which envisaged under the new law. So we'll go for the tea break, and after tea break we can start the other provisions on the search and seizure. Yes, sir.
I'll request all of you to please go to the portico first. We'll take a group photograph, then please enjoy your tea. Thank you.
Okay, so 105, completely new section. It was not there earlier, and very powerful provisions. So this ko lekar ke is really creating challenge for the law enforcement agencies, but it's really good provisions when we see from the point of view of the safeguards for the citizen of this country. So it's a very good provisions in that regard. Hi, sir.
Many occasions we have seen that there is a state amendment may, shall, legally. What is necessary for the state amendment?
Okay, that's.
If it is special laws or local laws, the matter will be different. Central laws, so that is why, sir, what happens? There is no information in all you. So far, the appointment of the director, so many other places. Yes. So my particular question is, if there is central law, why there is a requirement of the state amendment?
Because when I can give only answer that in federal system, the federal unit should have the equal power, and that's why the criminal procedure is in the concurrent list. So both center and state has power, and where the state thinks that they can add something or change something, they have a liberty. So we cannot curtail the government liberty when they want. So there are many amendments which done by the state in the CRPC. It's not only Odisha state, many state in the country they do make state amendment. So might be this wisdom of the legislature. They know better why they wanted to keep. So for the changes we says in prosecutor, the intention is we all know. You also know. I also know why the government amended section 24. So that's the system. In fact, if you know the cases on section 24, a very famous case of Vidyarthi, Sarla Vidyarthi, UP case, where as soon as the new government came, government changed complete prosecuting agencies. So she was made director of prosecution for a period. So she challenged it before Supreme Court. So it was Supreme Court judgment. And so issue arises that can new government change the entire cadre which was there, because new government came, they wanted their own people for the cadre of prosecution. In your Odisha also, just see in 1 or 2 months, many the panel will change in throughout the state. So the new government come, they want their own peoples to be most circumstances have been in power. So that was challenged before Supreme Court, and the issue was the role of the public prosecutor is as one of the functionaries who has to serve the justice system. So Supreme Court there, they say this change was illegal. You cannot change at a sudden. So then she was appointed, but later on again it was changed subsequently. So that time in Sarla Vidyarthi, probably Vidyarthi, the second name is as a case from the Uttar Pradesh. This happened in many other places also, the similar kinds of situation which arises. But yes, now because of the Directorate of Public Prosecutions came in the full-fledged way, hopefully the prosecuting team will streamline now. Because when we look at the clause 6 of section 24, now the section 18, the first clause idea is that public prosecutor shall be appointed from the cadre which exists in the state, and most of the state has cadre. The assistant public prosecutor are basically cadre of prosecutor in most places. So ideally the public prosecutor should be promoted from there. there are systems in the country, for instance, in Tamil Nadu, in your Bangalore, that Tamil Nadu, and few other places also, they have this system where the gradual promotions to the higher level from the magistrate court is goes. But some places it is not there. So like many of my friend who are appointed as an assistant public prosecutor in Bengal, they say their birth is with APP, death is APP. So there's no scope for the higher promotion. So, but they are experienced people, work for longer time, and there should be ways in which they can be promoted to higher skill. So hopefully the things will change. We can only hope. Ultimately, it is with the legislature to take a call, or maybe the judiciary to mandate. But court has not a mandate in very strict terms, because many state has make amendment in 24 clause 6 in the past. Okay, 105 we have seen. 107 is attachment, forfeiture, restoration of property. Yes, sir. Yes, sir.
So far as seizure of property is concerned, it should be video. And after how to preserve and interception, we have to we have to make several seizures. So how those seizures are to be combined together, or how to preserve that the child would be continued after 3 to 4 years, it may be sometimes 5 years, 10 years. So how to evidence and in what way the prosecutor can limit evidence.
Okay. What was the way earlier? There's no changes in the preservation of evidence. What the change has been brought so far, the seizure is concerned, like two things. One, evidence of guilt. Evidence of guilt we find from the seizing the materials. Videography is only to check that the procedures are being followed. So it will increase the reliability that okay, seizure has been done by in compliance with the procedure. Two witnesses were there at the scene of crime, seizure is being done. So the manner in which it is protected earlier, the seizure materials, there's no changes. What was earlier, the same procedure is being followed for the seizure materials. So far, these additional checks which are concerned, there's additional responsibility that okay, immediately you send the entire detail to the SDM or SD Judicial Magistrate First Class JM for FC. So the police may make the entire thing in the CD along with the entire things CD and the paper they will send to Judicial Magistrate, and the CD will have videography. So whatever the videos or audio they have done, that will contain the entire information of the search and seizure is being done. So there is no specific change in respect of the evidence of guilt. This recording by video is not evidence of guilt. This is only a process of the conducting search and seizure. In fact, in the Evidence Act, if you remember section 114, which is general presumption, one of the illustration of 114 says all official work done properly. So when an official work done by some authority, whether it's a public prosecutor, whether it's a police, a general presumption is they have done in compliance with the procedure, or when the court record a statement, all official or judicial work done appropriately or properly, those kinds of words are there. So when they recorded this statement, video things, they will send the copy to the court and that will be there. Definitely the police will keep those seizure documents along with the videos, and they will, when there's a submit police report, they will combine everything, entire thing will be in one CD and they will send along with the charge sheet.
Immediate after a seizure, it should be forwarded to the court.
Yes.
So, sir, during
Sir, a mic you can open because otherwise video will not catch. Yeah. No, just button ko aaj kar do. Yeah. Okay. Yes. Yes.
Sir, the provision says immediate after the seizure, the seizure would be done in videography.
Yes.
And immediate after seizure, it should be forwarded to the court. And the investigation period in BNSS is 60 days, 90 days, whatever. So during this 60 days and 90 days, there is different. There may be different seizures and
Yes.
different times.
Yes, it's possible.
So they cannot be get together.
No.
So there may be different CD.
Yes.
And if it is a CD, so it is a secondary evidence. So if it is a CD, we cannot prove secondary evidence without the primary evidence. So only CD, if supplied to the court, that cannot be taken into consideration by the court, because the defense may raise question that it is a secondary evidence. So it cannot be visualized, or it cannot be taken into consideration during appreciation of evidence, or comparing
Yes.
comparing the evidence of witnesses as well as the submission of the counsels.
Yes. Okay. Yes, sir.
The question regarding this is totally a procedure. So the procedure here is only to safeguard. So it is to be followed, but it is not concerned with the evidence. It is just like a CD. So as far as the law is concerned, use of CD, it is just that in the latter period it will aid the court. The court may see if the person turned hostile, for example. So we are not concerned with the electronics evidence, how it will be prepared and how it will be used. Because what is the evidence here? Only evidence that the witness turned hostile, and the witness is not telling anything. So in that, asking, that is regarding evidence. This is not evidence at all. In
okay.
that perspective, it's not recorded, because it will require further works to be done. It is to be taken to SFSL for comparison. The person who is attesting or who is making a signature on the list, the photograph and identification of that video, audio clip, and also secondary evidence we have to keep. We are not as far as
Yes.
it is concerned. It is only a procedure to be followed, and the mandate is that it is not perfunctory. So investigation is and as for law. That's
Okay.
all. In future, they will turn hostile, and it can be used by the court as a CD, case diary.
That's true. Okay. Yeah, that's true. The point is we need to make the distinction between two category of things. As I said, when we do search and when police do search and seizure, they seen contraband article or material. Those are the material to establish the guilt of evidence, guilt of the accused. This videography which the police is doing, it is a process to conduct such and seizure. So there is a general presumption the process done in the appropriate manner, whatever the law has recognized. They're doing investigation, so having a fair investigations processes. So these certification issues, etc., does not arises in the processes. You can just think about the same way when they prepared a seizure list, etc. Seizure list is a document which they prepared at the time of the seize. The guilt is the material which are being seized. Those materials will establish the involvement of the accused with the particular crime. So this video recording is bring some procedural safeguards and bring some transparency that the search, etc., is conducted in transparent manner and in the same time, same place, well documented. Now, if tomorrow the witnesses who signed in that videograph, it is shown that the two witnesses signed the seizure witness list. Today, when you conduct the trial, you must have faced many cases where the seizure witness come and they says that no, I have not signed, or they will say police has asked me to sign a blank paper, or they say sometime that police, I was at my home, police called me police station, they say okay, you sign this paper. So they turn hostile in different ways. When if it is conducted videography, the chances are more that these kinds of turning hostile will minimize. So because there's a human psychology, they know the entire thing is videograph, saying that will not be there.
That's why
Yeah.
that when witness turns hostile and there is a videography, then the prosecutor can confront the video by exhibiting in the court the video that you are the witness and you are putting signature, but you are not. So that's why my question is that can the prosecutors use that video during course of conducting prosecution case? So if there is no primary evidence, the defense may take advantage of that.
No, I think this will go in evidence, because just imagine the similar way. Suppose someone has done 164 statement to the magistrate. Tomorrow that persons come to the court and turn hostile. They say, I have not said this thing to the magistrate. There is a general presumption that the magistrate, judicial and official work done properly. So it's a general presumption attached that whatever the magistrate has been written, it is the person who has said it. Now, when something is, suppose that one hostile, what we do, that persons come to the court who are given 164 statement. The magistrate also come to the court in the given statement. The magistrate also, you can prosecutor say, okay, these are the things which they have stated. Through the magistrate, we admit that statement, because the exhibit is done normally through the magistrate who comes and say, this is the statement which I have recorded, and court take into account. Same way, when the videos are done, the police will come and say, this is the videograph we have conducted, this is the man which conducted, and this videograph which we have sent immediately to the court, this is that CD, this is this CD. Now, this is not the evidence of guilt. This is the evidence of the procedure, the process when it is conducted. The procedure does not require certification, because if you require certification, then imagine the situation. Every 164 when the magistrate record and it is audio video means they need certification. Every 161 when the police record by audio video means they need certification. Then it will become difficult in the trial processes. These are not the evidence of guilt. These are the processes which conducted by the court or some agencies during the processes. For that we don't require certification. So it can go in the court because it's a procedural element. The same way, why we sometime when some makes a statement and we call the diary from the court, general diary, that okay, someone make a statement that I went to police first, he recorded in a general diary. We ask for the copy of it. Now, normally we say primary and secondary, we distinguish them. Here, they recorded in the CD, sent to the court immediately thereafter. Court may ask for it that point of time, and court can rely because the general presumptions are there. Now, if suppose other one challenge that the video which contained in the CD is manufactured, is tutored, is changed, then they can rebut it. That's liberty is always there. The other party has a liberty to challenge anything, and they can come and give evidences about it. But as a general process things, we have a general presumption. So some safeguards might come today or tomorrow, as I was saying, that might be tomorrow by rule says that when the police will record by videography, they will keep on your no, not pen drive, sir. In the recording side, the locations thing. So this tomorrow no one can challenge that this is not being recorded. It was created in a studio. Someone can say in the different cross-examinations time that what the video we are saying, it is not of the scene of crime, but it is prepared in the entire studio. If the video says the location, then that challenge will go. Or for safeguard also, the police, I normally suggest to the police because technology permit it now. Only in the mobile when we are recording it, we can keep on the location also. So video is recording with location, so it's completely foolproof that the entire search and seizure was conducted there in that point of time. So I don't think there's a requirement of certification for this procedural thing, because these are not the evidence of guilt. This is evidence of guilt is what is being seized, and that need to be proved. This may help in those circumstances. Many times hearsay evidence is admit in the court. How it's admit? It's admit as a corroborative. So someone says that, okay, after this I said to that person's came. Now that person's statement is hearsay because he heard from the other persons. Now he can say, yes, he told to me. So many times in corroborations, we take the statement of third persons who has been specifically referred to by a witness. So it comes to corroborate the testimony. So in that way, this CD may go, and I don't think they will challenge it. If anyone challenge, they can rebut it. They say that, okay, this video is manufactured or changed or altered. Let they come and give evidences, but it can go in court, sir. I don't think there's a difficulty. Some challenges which might face in the future, we have to see. We have to be optimistic and see in future, but it's really very progressive provisions. And the challenge is not for us, challenge is for the police, because they have to comply with 107, which is an essential mandatory requirement under the law now. So it is making the search and seizure foolproof. Now we 107. Now before going to 107, 106, there is no changes except some minor wordings are changed. 106 is a replica of 102. Remember in the CRPC, old CRPC, that the 102 is the only sections where the seizures being conducted of any property which are proceed of crimes, etc. That is used in the 102 of the Act. And this is a very famous case of the Supreme Court, Parfulla B. Niyogi, where the issue arises, can police seize the bank account, whether bank account is a property within the meaning of 102 or not. And the Supreme Court make very clear in that case that because the argument was raised that bank account contained numerical number. Property means some tangible, I am touched the property. This is a numerical number only. So the lawyer argued that this is not property within the meaning of 102. In Parfulla B. Niyogi case, Supreme Court says that no, bank account, locker, all these are property because even if numerical number, it having the money of the proceed of crime. It is a property for the purpose of criminal because of money, which can purchase any property, and accordingly, bank account, locker, both are the property, and accordingly 102 they have a power to seize. So 102 become now 106. So 106 again very important provisions. Some minor changes are there, but not that extensive sections. 106, then 107 comes. 107 is completely in that sense the new section. 107 is a very progressive sections. So it is a attachment, forfeiture, restoration of the property is a new section, and then very powerful provisions. And I hope in future this provision will be used to bring more money in the state exchequer. So what the section says is, location if you find just after 106, 106 was seizure of the property, like theft property or other property, all those seizures can be under 106. Then come 107. I am reading this section because it's a very important section on new additions in the Act. Where a police officer making an investigation has reasons to believe that any property is derived or obtained directly or indirectly as a result of criminal activity. Now, again, the word you directly or indirectly. So you directly make the things much broader. From the commission of an offense, he may, with the approval of SP or commissioner, make an application to the court or magistrate exercising jurisdictions to take cognizance of the offense and commit for trial or try the case for the attachment of such property. Before taking evidence or after taking evidence, that means this process can be done during investigation. It can come during the trial stage also. It can be after trial also. So magistrate here has a play very important role in respect of any property which are proceed of crimes. If the court or magistrate has reasons to believe, whether before or after taking evidence, that all or any of such properties are proceed of crime, the court or magistrate may issue a notice upon such persons, calling upon him to show cause within the period of 14 days as to why an attachment shall not be made. So the magistrate can, on the application of the police officer, issue show cause notice, 14 days time limit, why it will not be attached. Where the notice issued to any person under subsection 2 specifies any property as being held by any other persons on behalf of such persons, a copy of notice shall also be served to upon such person. So benami property, if someone else is having the property of others, which normally happen when the black money, etc., or illegal obtained monies are there, money is kept by someone else. We know in West Bengal, one of the ministers, the huge money was found not only for his premises, but also from the some other person's premises who is acquainted with him, so very close to him or having relationship with him, her. So it was found from the other places. So in both circumstances are there. So when issuing this attachment, etc., a copy need to also serve to the person who is having that property on behalf of the other. So proceed of crimes, clause 3. Then court may or magistrate may, after considering the explanation, so after 14 days he can come and give explanations, or if any, to so called notice issued under 2 and the materials facts available before such court or magistrate after giving a reasonable opportunity of being heard to such persons or persons, may pass an order for attachment in respect of those properties which are found to be proceed of crime. So anything which are found to be proceed of crime, court can pass that order if they think this is the money of the proceed of crime. Provided that if such person does not appear before the magistrate or represent his case before the magistrate within the period of 14 days is specified in the so-called notice, the court or magistrate may proceed ex parte. Clause 5 says, if the court consider that giving notice may siphon the amount, siphon the property, so it may endanger the property itself, then in those circumstances, the magistrate may again pass the order ex parte. So clause 5 says, notwithstanding anything contained in subsection 2, if the court or magistrate is the opinion that issuance of notice under subsection would defeat the object of the attachment and seizure, the court or magistrate may by an interim order pass ex parte direct attachment or seizure of such property, and such order shall remain forced till the order under subsection 6 is passed. So at the time of issuing the notice itself, if the court think that if we don't attach now, the property will siphon or disappear, etc., this might happen, court can pass attachment that time only and they issue the notice. Then the person will submit and give objections. Clause 6, then the magistrate will find the attachment and seized properties to be proceed of crime. The court or magistrate shall by order direct the district magistrate, what do you see, ratably distribute such proceed of crimes to the persons who are affected by such crime. So all this property which is found as a proceed of crime, magistrate can pass order, ask the district magistrate to distribute that money among the victims, and the distribution shall be ratably, so proportionately of their suffering or the loss, whatever the money they have lost there. Clause 7 says, after receiving this order, district magistrate will ratably distribute among the victims. After distribution of the victims, still if there is a surplus money, or if there is no victims, no victim came for claiming the money, in those circumstances, such proceed of crime shall stand forfeited to the government. So these sections could open a possibility for enormous amount of fund which can go to the state exchequer from the proceed of crimes. So in the lighter note, when the government make their target of revenue for next year, they may fix a target for this also, that how much money we are getting from the proceed of crime, because this revenue may give for development of the infrastructure for the court and judiciary. So they can say, okay, whatever money will come, we'll invest on the judiciary, prosecutor and the police system. Yes, sir.
Come to subsection 1.
Yes, sir. Yes, sir.
Once the property is derived or obtained directly or indirectly
Yes, sir.
as a result of criminal activities, number 1, or from the commission of any. If the prime requirement that there should be an effect.
There should be, sir.
Suppose in a DA case or a police.
So in NDPS case it is going on, this problem to some extent it is affected in NDPS. Monetary offense.
So there are the person has a lot of legal processes. So that if the affair is lost for a particular case or particular thing. So how could we regarding the criminal activities? That means there are a lot of criminal activities by that person, by the accused. But a particular case is instituted for a specific purpose, cheating of money perhaps, and from a bank or something. He has the accused has related in different crimes, and it implies that all the criminal activities are the properties derived from this case.
Yeah. So idea is to start this process, you must require some case. To give you example, suppose someone is a trafficker.
In a particular case, now we are concerned with 20 lakhs, 10 lakhs rupees.
Yes.
Allegation is for that. And it is there, the material is there to prove the disproportionate amount, it's 10 lakhs. But during investigation, it is found that the person has derived a lot of property that is from other criminal activities, not in this case. Is it the mandate of law as far as subsection 1 is concerned that that property will be included in this issue?
Sir, wording, that's why it has very broad, sir. So there's a directly, indirectly, as a result of criminal activity. Just to give you an example, I forget the name, there's a trafficker who usually trafficked more than 300 girls from Nepal to India and have crores of money, bungalows, assets in Delhi. Now in jail, entire jail person is. Case might be started for one trafficking. So all this property which obtained or which generated not from the legal channel, it's all come from the illegal channel. So so-called notice will be there. If the property is obtained by the legal channel, he will challenge. But if it is done out of these continuously income and generated this huge money of 100 crore, 200 crore, we don't know how much money a criminals normally have. It's a few days ago, there was a raid in Calcutta, one of the promoter's residence, and ED was counting money throughout the night. So if a smaller promoter in a local area, they have such money which can be counted throughout the night, we don't know how much money people save. So in all those situations, probably because of these broad wordings, broad use of the wording directly or indirectly, as a result of criminal activity. So the case will definitely start with what? Without cases, you cannot start.
I do understand that.
So then these will come automatically. And there is a risk that it can broaden. The word is so broad that it can cover the proceed of the other crime also.
A person is a poacher. And that person is also a drug peddler.
Yeah.
And also trafficking. Now case is instituted for trafficking. But he has collected huge amount from
the illegal
poaching,
activities. Yeah.
from drugs business. So whether this can be connected with this particular.
The language, sir, what is your view? If you read these things directly, indirectly, as a result of criminal activity or from commission of any offense. So again, very broad word.
For the commission of the answer, okay. Like in criminal activities, can prosecution prove that? Sir, coming to subsection 7 and 8, sir.
Yes, sir.
Subsection
So
7.
language is very broad. I can see let's the what directions comes, but language is a potential where it can cover the other also. 7.
The district magistrate has been authorized. I have the power within a period of 60 days distribute the proceeds of the crime by himself, rightly. So is it not a pre-trial judgment? When the sale proceed will be distributed, the crime is not proved. At that time, judgment was not passed.
Yeah. I agree completely with you, because then the issues comes about the accused always has a presumption of innocence till proven guilty. It might, even in that case, all witness turned hostile and the persons got acquitted. So hearing is given to him. Accused. So clause 4. 4. So reasonable opportunity is given to him. Now, so question, the risk is that many people, businessmen, etc., there is a risk that their property, etc., might be confiscated, etc., under these sections of the law. Now, under the Money Laundering Act, I think they are going to change, or they have changed already, GST offenses all coming there as a part of it. There might be a large number of businessmen might be. There's always invariably there are many businessmen who don't compliance with all the requirement of the GST, etc. Now, in all those circumstances, proceed of crime. So whatever the money a businessman drawn, and if it is not able to prove it is because opportunity is given, if not able to prove that it's come from the genuine sources, then court can proceed. But those are the right issues, that what will happen if tomorrow he got acquittal in that cases. But on the contrary, he also unable to prove that it is the genuine money obtained from the right sources. So entire shifted on burden on the citizen, that to keep themselves ready, that whatever money they have, it comes from the genuine sources, because this is the risk. Talwar is always on the shoulder of the persons, and that can be used, because language is very broad. So we need to see how this act can be enforced. From the victim point of view, yes, if the victims get compensation, but there is a chances that it might be misused in some cases. It might be extensively used against some group of people, particularly those people who are not having a legal business or not following the procedures of the things. GST, etc. How many businessmen, smaller businessmen, they use all those GST systems, and then the proceed of money, this section can be used. So yes, it has both angle. It has the angle where the property can be confiscated. Fair trial principle can be fulfilled by giving them opportunity, but many businessmen might not able to prove their income, source of income, though they have done business in the proper channel, proper procedure, but they have not compliance with the regulatory requirements are that many businessmen does not fulfill the regulatory requirement. So a businessman might be selling a flat with 1 crore. They do the purchase 60 lakh rupees. So 40 lakh rupees are illegal obtained money. So it's a done business. But only thing, they have not done the regular requirement just to avoid the taxes or GST, etc., etc. Nowadays, all kinds of things have a taxes. So that risk is there. So new provision, hopefully. So what the normally ED is doing throughout the country, the police can do the same thing. By using these sections, the illicit money can be used, confiscated, and the amount can be distributed among the victims. So that risk is there, and let's see how the court react. Because many times there's a chances of misuse also of these provisions. होता है क्या? हाँ, that's true. So, but when we see from the victim point of view, we don't have similar provisions earlier. Say, for instance, in West Bengal, there is a cheat fund ghotala. Suppose the money is found by the companies. If these kinds of provisions are there, whatever the seized money can be proportionally distributed among all victims. So at least these provisions can be used in those circumstances where public cheat fund, etc., when the crimes are being committed. These are all proceeds of crimes money which are seized by so all those cases it can be done. Okay. The chapter 8 was on the reciprocal arrangement for assistance in the certain matters and procedure for attachment and forfeiture of the property with the member country. The same thing are the 112 and 103. This provision has little bit streamlined, but the same thing which is there. So chapter 8, whatever was there earlier, they have included it in chapter. So not made any major changes. Some procedural, this says letter of request, etc. Nothing else. Chapter 9 is on the security for keeping peace and good behavior. Only thing is, law has referred to updated provision of the law. Like there many places they have referred to this IPC. So they have referred to the BNS provisions in this. So no much changes in the chapter 9 also. Section number has changed, but not per se any specific changes. Chapter 11, maintenance of public order and tranquility. When the armed forces, there's a 2 sections earlier, 129, 130, 129 for police officer, 130 for the armed forces, used by armed forces. So there, earlier it was use the word any highest rank executive magistrate present. Now this says any executive magistrate authorized by him. So DM or any executive magistrate, that's the word is there. So not major changes, just this is earlier it says highest rank executive magistrate present. Now says any executive magistrate who are present. Then 154 persons against whom conditional order for removal of nuisance proceedings are going. Now this section basically, remember in the CRPC 133 onwards, all those executive magistrates role, etc., goes to 144, 144, and then 143, and then 144, etc. Those sections were there. 144A has been repealed. So in those circumstances, when public nuisance order was removal was there, that order can be the court can allow, executive magistrate court basically, they can allow the party to appear by audio video conferencing, that permissible. There also the time limit is being fixed. The proceeding to be completed within 90 days, which can be extended to 120 days by recording the reasons in writing. So the time limits are there within which the entire proceedings of is done by the executive magistrate normally, that need to be completed. Earlier 6 months was, sir, in 144. 117 also, 110 also. So 4 months. Preventive actions by the police, not any changes. They have used the word judicial magistrate. So they will, where they produce the persons if the need arises to the judicial magistrate, that what they have used. 172 is a new section which they have added in that chapter. Now this is again a general section. Basically, when police is giving some kinds of a directions, the person has to comply with the directions, and if they don't comply, we know against that we always have IPC earlier. So they can, if any person does not comply with the police directions, they can be prosecuted under the IPC. It was earlier also. So now they have added a provision just to say that if you don't comply with it, the consequent impact will be on the BNS, that Nagrik Suraksha. All persons shall be bound to conform to the lawful direction of the police officer given in fulfillment of his duty in this chapter. So it's basically preventive measures. A police officer may detain or remove any persons resisting, refusing, ignoring, disregarding to conform to any directions given by him under subsection 1, and may either take such person before the magistrate or in petty cases release him as soon as possible within a period of 24 hours. So that's again good provisions they have added, that when the police give directions, they given the power also, if the person are not dispersing, they have a power to arrest them, detain them basically, and then produce them before the magistrate for non-compliance. So 172, this is a new section which was not there in the CRPC earlier. So 172, persons bound to conform to the lawful direction of the police. We have already, we just discussed. So a police officer may detain or remove any persons resisting, refusing, ignoring, disregarding to conform to any directions given by him under subsection 1, and may take such person before a magistrate or in petty cases release him within 24 hours. Then chapter 13, which is basically investigations, and there are many changes which we have seen the investigations part, which include now starting from the FIR provision. So earlier it was 154 to 173. Now it starts from 173. So just it's a reverse from 173 to 196 in the new act, the entire chapter on investigation. So changes we can see in these sections from the beginning itself. When we look at say 173, the FIR provision itself, because many times we use the word zero FIR. Now CRPC does not say anything about zero FIR. So now in the section itself, they given a smaller margin without any jurisdiction. So FIR can be at any police station. So 173. Every information relating to commission of a cognizable offence, irrespective of the area where the offence is committed. So that means without any jurisdictions, if someone goes to the police station, they have to register FIR. May give orally or by electronic means. Again, the new entry. FIR can be by electronic means. So clause 1, orally. The same thing which was earlier, if given orally, police will reduce into writing, and then the form prescribed in which they will write the FIR. B, by electronic communication. In that case, if they are given by electronic communications, then police were prepared the everything, and the person has to come within 3 days to sign that. One of the confusions can come when we can consider FIR. So that the time when the person is communicated, the time when he is signing, because within 3 days, now within 3 days might be after 1 hour, might be after 2 hours. So, so my view is that if we can just imagine the earlier situation, someone make phone call to the police that this thing is happening. Police came to the scene of crime, did whatever is required to, go back to the police. Person also went to the police station. FIR is being registered. So the scene of phone which is there, the police write in general diary that someone has made the phone call, etc., and then proceed to scene of crime. The same way, this may happen. The police can proceed, but FIR, the original FIR will be only registered. Like the formal number will come when the person will sign it, because they have to come within 3 days to sign it, that FIR. But in between, the police do has the power to do preliminary work. Or in some cases, police may themselves can register suo motu FIR also. So initially they receive information by email, but we have to see all these things once the rule will come, because it might be that every government may come up with a website with every police station level. You can go to the website, the form will appear, person will fill up the form, you can send the form will come to the at the police station level. The other staff can give input, OC can give input, and then waiting, take print out, the person will sign, the numbering will be done, and then the FIR will be registered in the hard copy of that particular document. So these all can need clarity once will come, once the rules will be there about the FIR. But now that we have a new concept of EFIR. So by electronic communication also, the FIR can be registered under clause 2. Provided that in these are the section which are the sexual offenses. So all the rapes, 376, etc., all those comes here. हाँ सर जी सर it will go as a part of the case record, sir, undoubtedly, even before the FIR is registered. Okay, FIR will be time when the person will sign, but the investigations report, everything, whatever the police will go, everything will go as a part of court record. Just think the other situation. Police is doing, whether it's a 3 days or 3 hours, principle is same. Suppose police are doing a round check in the night. In a vehicle, they found some contraband material. They seize it. They arrested the accused. No FIR is registered. They come to the police station, write down in a general diary, then take approval of the officer in charge, and then register the formal FIR. Now, this act which is done in last 1 hour or 2 hours or 3 hours by the police, they are all part of court record. So whether it's a 1 day or 3 day, as because it's happening by virtue of a legal procedures, whatever police will do during those interim period, it will go as a part of the court record. Now, question is, these development where the police will write. Case diary will start once the FIR number is there, but seizure list is done. So might be rules will clarify that they will write down in general diary, they write everything. No, for registering FIR, for the this thing will be clarified by the rules. But my impression is, till the time the signature comes, the numbering will not be done. Numbering will be done only that. That does not mean that the police cannot do preliminary investigation. They can do preliminary investigation even till the time number is done. Because the same thing police do now also. Suppose someone make phone call, and then police go to scene of crime, do investigations, and that person may come after 6 hours. Then police will write formal FIR. The person will sign. Whatever work done in last 6 hours, is it not counted? It's counted. So same principle here. Even if 1 day or 2 days, 3 days is the optimum limit. It can be within 6 hours. It can be within 1 hour. The person will, whole idea is that when the person will come, sign because the signature is necessary, then the numbering will be there. Alternatively, there is no prohibition that police will not register suo motu FIR. So police will write that I got this information by this, etc. And then if the difficulty arises, suppose the person did not come at all, send the mail and did not appear, but there is an offense being committed. What the police will do? Now the police has only options to cover it up is they have a suo motu FIR, because if any information which is given, if transpires cognizable offense, police has no option. FIR has to be registered. So if the person is not appearing, then suo motu FIR. But that's my impression is that's the only way in which we can make this provision workable. But the provision has to make workable when the provision has come. So police will have to wait, but this will be definitely counted. There is no prohibition in the counting this. Naki dada, aro ki job hai? I think the same thing will happen. So he's a senior police officer, so long time he worked in the department. So my impression is it will work in that way only. So we have to find out the ways in which it can be workable solution. Okay, in the sexual offences cases, it shall be recorded by women police officer or any women officer. Or any women officer is sir. Okay, again this is a confusing provision. I don't know why they have added this provision. Because in the police department, even if the officers are, when we see the officer in charge definition in section 2 and the old section, new section, again I have to take time to remember 36. If you read the definition of officer in charge and section 36, from head constable to DG, everyone can act as an OC. That's the provision is. From head constable to DG, they all can act as an OC. Law permitted. So probably women police officer who are designated the officer, or maybe some any women officer does not make any differences, but why they have used it, no idea. So might be some other officers, maybe some specific categories of officers who can, executive authorities might be there who can be empowered to do something. I'm not sure, but under the law till now there's no empowerment is there. So and now in most places, many times now we bring the law for betterment of a group of people, and that become counterproductive. Just think about the women conditions. Now in most places, in every district, there's a one women police station in some many places. And the district headquarter is from the women residence to the police station is 100 kilometers. If had that lady, if she had been a man, she can go just 2 kilometers and register an FIR. Because she is a woman, she has to travel 120 kilometers and register FIR. So it creating challenges also. So we say special class, we have a special police stations. Like idea is instead of women police station, women officers need to mainstreaming. In every police station, there must be women police officers who can serve it, so that the women should not travel to 100 kilometer odd to go to the women police station. So it's required by the women police station in women officers in some places. Okay, this is another margin. In the event of that, if those sexual offenses are happened to a person who is mentally or physically disabled, then there's a two additional requirement. One additional requirement is that the police officer has to go to their residence or any place of their choice for registering FIR. Now again, this has to be prescribed by the rules how it will be done, because FIR copy, which are normally registered, it has to be at the police station. It does not go to the order of the police station. So we must have to working solutions where the FIR can be prepared either online in the website where you can fill up, sign, take print out, or some modalities need to work out. So person has to go to the win place. Second, it has to be videograph. So that's the requirements are there. And the police officer shall get a statement of the persons recorded under 183, which is basically 164 statement. So those victim statement will be recorded under 183. A copy has to be given free of cost to the informant. Now 3, this is a margin which is given, and this is I think may create some kinds of hurdles. So under the present law, in both places, in the FIR as well as in complaint, both places some hurdle is created. And how this hurdle is created? In FIR, if you see, if there is any offense where punishment is 3 years or more but less than 7 years, in those circumstances, if the OC does not want to investigate, in order to ascertain that there is a prima facie case to proceed with, he can, with the permission of DSP, within 14 days, they should do prima facie inquiry. So so this is again to bypass FIR and investigations immediately. Some prima facie satisfaction is required there. Now there the question comes whether this prima facie inquiry, which is said in clause 1, is it after registering FIR or before registering FIR? If after registering FIR, does not make any difference. You have already registered FIR. So once you registered FIR, you have to proceed for the scene of crime for doing some work. So impliedly, probably in the Lalita Kumari judgment, where Supreme Court says that police has a only margin available to the police is till the time police is not sure whether it's a cognizable offense or not. So in order to ascertain whether offense is cognizable or not, police may do some preliminary inquiry. And as soon as they are sure that this is a cognizable offense, they shall register FIR. Probably keeping in mind the Lalita Kumari judgment, this first part is added, that in these cases where the punishment is 3 years to 7 years, with the permission of DSP, police can do preliminary inquiry, and that period is within 14 days they have to take a call. It's not mandatory, optional, because 2 says or proceed with the investigation. So they can proceed with the investigation of the case if there exists a prima facie case, when there exists a prima facie case. This is the one thing. So some hurdle is here in that respect, they have been created. In complaint case, what is the hurdle is created? Now what happened in present a complaint case? When you file a complaint, magistrate will do essay, we call. So 1 or 2 witnesses, preliminary statement recording, we call it normally, I don't know what's called here. It's normally in Bengal, we call essay proceeding. So basic statement, 1 or 2 persons are recording. Why this record? Just to get preliminary satisfaction that is a case has been made out. And as soon as this case is made out, magistrate will take cognizance. How we know cognizance being taken? Either sometime they put stamp and sign cognizance taken, or they issue notice, summon. If the summon is issued, implied that the cognizance is being taken. That's implied condition, because that's the only step. Next step we can go. Cognizance is taken by the magistrate. Now what the new law says is that in complaint cases, when someone filed complaint, before taking cognizance, magistrate should give opportunity of being heard to the accused. So how do we get opportunity of being heard? The only way you can to bring someone before the court, only process summon. So you have to issue the summon. If you issue summon, the opportunity you are giving. So now we have a system we are going to develop where even in complaint cases, we have to give accused up or to be accused a prior intimations where the accused can come and make their views, and after hearing the accused only, so after giving opportunity of being heard to the accused, magistrate will take a call whether to take cognizance or not. So again in complaint case also there is some inbuilt hurdle is created in accessing that proceeding. Probably it is for the reducing the number of fictitious cases, etc. Because in the villages many times, no, it's not only village, everywhere the people who is supposed to file cases, they do file cases. So if I have to harass someone or someone's love me so much, if they want to harass me, they will say, okay, Sarfraz has come to my home yesterday. In the morning, I asked him to stay. In the morning, when he left, I found that my valuable things are missing. He must have committed theft. You go to the magistrate, file and complaint case, and poor Sarfraz has to come to the court every day whenever the dates are there, because cognizance is being taken. So in those kinds of situations, to avoid, might be it's created an impressions that the false cases can be reduced. That might be the intention of in these both places. Refusal, if the person is agreed, the same principle what was there earlier. The clause 4 was earlier also. In the new law also it is clause 4 that they have to inform the SP, and then the SP can take a call. Okay, another changes. So 174(1) information as to non-cognizable offences. Forward the diary of the report to all cases fortnightly to the magistrate. This is a new thing which has been added. So fortnightly report has to be sent to the magistrate. Information about non-cognizable within the limit of a police station. SHO has to enter information in a book which prescribed for it. Police officer has to investigate cognizable cases 175, which is earlier basically 156. The provision, the same thing. Clause 3, JM may order under 175 upon the receipt of the application under section 174. So there also the opportunity of being heard is being given. Judicial magistrate may take cognizance in the complaint about the public servant arising in the course of discharge of the official duty, subject to receipt of the report of the officers superior to him regarding the fact of incident after considering the assertion by the said public servant. So when the public against the public servant, some cases are being filed, complaints are being filed, additional requirement that the superior of that public servant, from them the report need to be asked, and after looking at that report only the magistrate will take cognizance. So that restrictions are there. So procedure of investigations, clause 3, on every receipt of every information relating to, this is another addition which was not there earlier, and very progressive provisions. Remember, we don't use forensic science evidence very seriously. Yes, sir. Yes, sir. Yes, sir.
There was complete information regarding the community details. Then the police were empowered to register the affair. The telephonic or electronic message, the complete information regarding the person who is giving that message. So the police were empowered to register the affair. Basing upon that information, and accordingly, he was investigating. In earlier, so, sir, in present case, the Act BNSS provides a 3 days time to the person who has sent the message through electronic means. So by that time, these 3 days. So how it is to be complied, sir?
Okay. I think
Because
3 days time is a maximum limit. It's not the minimum limit. So a person who sent email for registering FIR may appear to the police within an hour or so. So in the same way, if someone make phone call and then in after 1 hour went to the police station and signed that thing. FIR is only complete when the police make phone call which is an FIR is registered. Police does not register FIR immediately. Police write down these things in the diary by saying that Mr. So and so make a phone call alleging these things happened. And so they proceed to scene of crime. So they will write an exit from the police station because they're going to scene of crime. When they come back, write entry to the police station. And thereafter, in between, the person will come. And by following their own procedure, they restart the FIR. Because FIR need only signature of the person. So person used to come, then only the FIR is being registered. The same thing happened now also. So as soon as the person will come within 3 days, it can be 1 day, it can be 2nd day. When they sign, then the investigation FIR process is complete. That does not mean that before that they will not do investigation. If there is a prima facie case, they can do preliminary
definitely,
investigation.
sir.
That power is there.
Definitely, sir. They can investigate.
Yes,
but so far as the case number is concerned, whether it would be station diary or FIR number. If he, because 3 days there, suppose I sent a mail to the police station that this is the regarding an incident, and I have 3 days time, and and after receipt of my email, the police started investigation and found that it is a cognizable case and there is sufficient material to proceed in investigation, and accordingly, as per the station diary entry, he had to proceed. And on the 3rd day, the informant who had given the mail reached before the police station to sign in the FIR. So whether that person will sign the FIR or not,
no,
and which FIR will be sent to the court.
Okay, FIR will be only, there will be only one FIR. There will be not two FIR.
Sir,
The numbering will be, in my view, it will be only after the signature. Before that, the numbering will not be there. We have to wait for the rules to come because rules will clarify it. My impression is numbering will be only after the signature by the parties. That's what happened today in the other cases when someone's make phone call or other. So we say earliest information is FIR, but in real sense, that information recorded in the general diary and then later on converted into FIR that is signed by the person who make the phone call. So in between, whatever the information is being collected, that can be used. But suppose what happened is the accused being arrested. Arrest accused has to send within 24 hours. Now that person has not come. Police has to send the accused in 24 hours. Now to working solution will be that definitely police has come to conclusion that the cognizable offense is being committed by visiting the scene of crime, by collecting some evidence at that point of time. That time only working solution is that ask that person to come and sign. But if the person is might be some other places, then register sumo to FIR. The same police officer will become informant and they will say that it's transpired from the communication by that person that is a cognizable offense and they can register FIR. So sumo to FIR will be happened. That can be only working solution for this situation, sir.
sir, then the mail, how can the mail is to be used?
That will go because it will become part of the already record, na. So that will become part of the general diary. That will become part of the case diary. So tomorrow that person will become witness. So whatever the witness provision is there, police can make him witness. So he can go to the court as a witness and give evidences that yes, I sent this email.
That means
I sent this.
sir, the messages of the mail would be drawn by the police as FIR, and that is to be sent to court for proceeding of the investigation.
Yes, it can be. Now, just imagine when police receive an information from their informer. Information from informer are protected under the law. You cannot compel to the police. What the police normally write, I got information from reliable sources that this thing being happened, and thereafter I recorded in the general diary. No name is being written. I went to scene of crime. I found these materials. Sumo to FIR registered. Here they will written, I received this information from that person by email. Person has not come. We have arrested cognizable offenses. It will become sumo to FIR. So that's the only working solutions will happen in these situations. But many things will clarify when the rules will come. Because might be tomorrow the government will come up with a website where you can go with the police station label, you can fill up the detail, you can write there, then some input by the superior, etc. And thereafter it will be drawn as an FIR, it will print out, the person will go and sign. So signature he can come and go. But if it does not comes, then police will write that thing and make a sumo to FIR if these are really offenses. Because if something reveal an offense, police has to register FIR. Police cannot say, I will not register FIR. So that's the only working solution. Nothing else. Okay, new thing which is comes. Forensic science. Many places we don't use, we have not taken forensic science very seriously. Now the new law has given very serious input. So any cases where the punishment is more than 7 years, the police officers must take forensic scientists with them to the scene of crime for collection of evidences, etc. Some margin is given for 5 years because we are not ready with the manpower. And the forensic scientist manpower cannot be ready in 1 or 2 days. It will be ready maybe another few years because now almost 10 universities in India are offering forensic science courses, bachelor degree, master degree. In my university also we have started MSc forensic science courses. Almost if anyone's family member, known people, if he's a science graduate, the form is open now. Those who will do MSc forensic science, everyone will get job. Because now such a demand will come for the forensic scientist. So NUGS form is open for another few days. You can ask your relative to apply there. So there's a very good course. So now the thing is, the idea is that the forensic scientist should be there. Long ago, we conducted a research in Calcutta on the rape and murder cases. We took 100 samples and try to find out how many cases there is a possibility of using forensic sciences and they have not used it. And we found there's all 100 cases, there was a possibility of using forensic sciences, but they have used only in few cases. Very slight number of, a smaller number of percentage of the cases they use. Long ago in 2002, there was a committee, Justice Malimat Committee report. And that Malimat Committee report suggested that there's a term they have used called SOCO, SOCO, scene of crime officers. So the idea is that whenever an offense happened in some area, at either district headquarter or subdivisional level, there will be a team of the officer which consists of police, which consists of other officials, it consists of forensic experts, cyber forensics now, and they can go to the scene of crime to collect and preserve the forensic evidences. Because we have to rely on the forensic evidences. So now it is coming in big way. Yes, sir. Expert. So there is a many places they are gradually using. Our manpower state need to be in state forensic science laboratory need to be equipped. Probably in district level we must have forensic science district, because how can from whole state will come to only one SFSL. So things time within the few years we will find more forensic science laboratory in all process. So provided that where the forensic facility is not available in respect of any such offense, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of other states. So they can work out solution with the other states where they can use forensic science. Police powers to require attendance of a witness. Earlier it was 160, now it's become 179. Some changes are there, though it was the same thing which was there, provided that no male persons under the age of 15 or of the age of 60 years or women or mentally physically challenged persons to go to the police station. At their statement should be recorded in their place or place of their choice. Provide further that if such person is willing to attend at the police station, such person may be permitted to do so. So this provision probably is new. The state government may, by rules made in this behalf, provide for the payment by the police officer of the reasonable expenses of every person's attending under subsection 1 at any place other than his residence. So state has to pay money for police for the expenses which is incurred to them. I think in the court system also we need to start this practice. If a witness comes to the court, their traveling expenses must be paid immediately to the witnesses. The day we are able to start, the number of adjournment will decrease.
That is going on,
Sir?
That is going on.
It's being paid. Yeah.
Police station.
Now this is started with the police. Okay. What are the other changes? 183, recording of confession statement, only judicial magistrate. Earlier also it was only judicial magistrate. It has added, maybe it can be by electronic, audio, video, electronic means. So even 164 statement, which is now 183 statement, it can be done by audio, video, electronic means. First proviso to subsection 6, statement shall, as far as practicable, be recorded by a women magistrate and in her absence by a male magistrate in presence of a woman. So that's again the new development. So women, offense against women, in those cases, statement has to be recorded by the women magistrate, or if the women magistrate is not there, then any one women should be present during the recording of the statement. Subsection 6, mandatory recording of the statement of the witness in cases relating to offense punishable with imprisonment for 10 years or more, or imprisonment for life or death. The magistrate shall record the statement of the witnesses brought before him by the police officers. So when the police bring to them to the magistrate shall mandatorily record the statement of the witness in those cases.
164 now.
164 now. So it's become 183. Audio, it can also be done by the audio, video, electronic means.
Sir, in 164 statement, there is a procedure, a difficult procedure in our Odisha judicial system, sir. We are finding the police officer, suppose in a POXO case. So POXO code is there in one district, and the local police station is about 100 kilometers is there. If a police officer wants to record the statement of a victim under section 164 CRPC, then he is to produce the victim before the magistrate. But in our practice, we are seeing the police is coming with the victim to the POXO court. why the act provides that the statement is to be recorded on production of by the police before the statement to be recorded by the magistrate on production of by the investigating officer. But the practice is the police will bring that witness, the victim, to the POCSO court, and the POCSO court will redirect the police to some else magistrate, and the magistrate is recording the statement. So why this procedure is going on? And
No idea why.
sir, as your kind authority has given has opportunity to enlighten this matter may be clarified in the academy, so that this procedural lacuna may be clarified in our state, sir. Because almost 100 kilometers, that is the expenditure is going from the state exchequer. Why the police officer from 100-kilometer distance will come to the POCSO court for recording of 164 statement without producing victim before the nearest magistrate? So that is a very peculiar circumstance in everywhere in the Odisha we are facing. So
Okay. Now, in West Bengal, the general practice is that we don't take to the magistrate or POCSO court for getting the dates. So there is a one application by the police that so and so victim we want to examine under 164. So we know the court will give the date. So court will there give the date, specific date. That time victim does not require. So when they given the date or any specific magistrate, victim will bring there only. So 2 times victim does not require to bring. So that's the practice in West Bengal. So in the first time when we are taking dates of the court, that time we don't bring the victims to the court. So that's for getting dates, no need of victim bringing. Date can be get and the court can identify the specific magistrate. That magistrate where the victim will be produced for 164. And now it has been added, it can be done by audio, video, electronic means. So many these kinds of a problem may solve when we started conducting by audio, video, electronic means. Okay, so that's again audio, video, provisos 6. Audio, video, electronic means, and with the help of the interpreter. So if there's some interpreter, their helps can be taken for the purpose of recording of the statement. 184, which is basically medical examination of the victim of rape. 164A basically. 164 become 184. Now here I said earlier, the medical officer has to send the report within 7 days. Same principle. It has to be done by the female medical officers. In the absence of any female medical officers, any other female medical practitioners, and the report has to be sent within 7 days time. 185, search by the police. Reason for the search, ground of belief shall be recorded by the case diary. It was there earlier also. It can search shall be recorded by audio, video means, preferably mobile phone. Clause 5, record of the regions of search and deputing subordinate officer to make a search. Subsequent 3 shall be sent to the magistrate within 48 hours. So search report has to be sent within 48 hours. 184 is basically your 185 is 165. So 165 become 185. 187, it's basically 187, 167, which is there in the present CRPC. So judicial magistrate to account for the status of the bail, 15 days PC is spread over 40 days or 60 days. This is the new thing. Now, even though earlier there's a few cases where court do allow the PC subsequently, but the general practice was that the PC can be only in the initial period, and there once the JC is there, then accused will go for JC, not the PC. Now that change has been made. So wherein the clause 2 says the magistrate to whom an accused person is forwarded on this section may, irrespective of whether he has or has no jurisdictions to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled. So both ways, there might be person has got bail has been cancelled and got in custody. After taking into consideration, bail has been cancelled from time to time, the detention of the accused in such custody at the magistrate thinks fit for a term not exceeding 15 days in a whole or in part and any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days. So in 60 days period become 40 days. So like when 60 days, in the cases where the period is 60 days, within 40 days, In the case where the period is 90 days, within 60 days, magistrate can send for total 15 days in either custody, either judicial or police custody. So that means the police custody can be for 15 days. Within this period of 40 and 60 days, it can be at once, it can be multiple time, it can be in break. And thereafter, all the custody will be only judicial custody. So apart from the 15 days custody, other custody will be JC. So nothing changed. Earlier also it was 15 days. But earlier it was not clarified that during this 40 and 60 days period, it can be any point of time. So maybe initial the persons got custody for 2 days PC. Thereafter went to GC. Now again, IU may apply for the PC again within that 40 days or 60 days period to get custody again. This is permissible under the law. In part. So it can be any time within this period. So that gives a margin to the prosecutor to argue that we require his PC and don't give bail. So when we oppose the bail, this is always one of the ground that, okay, we require some recovery might be taken. So bail is not the appropriate time to grant bail. So one argue public prosecutor can always made in those circumstances. Okay. 190 cases to be sent to the magistrate when evidence is sufficient. There is a provision. Lunch break. Again, I'll just take a few things I will finish and then I'll go. Yeah. Information to the police officers and they are to investigate. 190 cases to be sent to the magistrate when evidence is sufficient. One provision has been added. Police to take security from the persons to appearance when not in custody and magistrate bound to accept it. So, provided that this is a situation when suppose a person is not arrested, police is going to submit charge sheet. So, in the charge sheet form always says custody or absconder. Arrested or not arrested. Now, here when they are not arrested, they can show that this is the undertaking they can take from the accused that as and when court will require, they will go to the court. So, that is the requirement. So, the provided that if the accused is not in custody, he is not arrested because police does not want to arrest. 41A. So now he becomes 35. So police does not want to arrest. So in those cases, they can net an undertaking that he will come to the court. That was the requirement. So provided that if the accused is not in custody, the police shall take the security from such persons for his appearance before the magistrate, and the magistrate to whom such report is forwarded shall not refuse to accept the same on the ground that the accused is not taken into custody. The timeline is being fixed like rape and POXO time limit 60 days. Police shall inform the progress of the investigation within 90 days to the victims. Responsibility of the IO to submit copies of charge sheet. Now this is as a general practice, police normally submit all copies of the charge sheet because to give the accused. I don't know what happened in Orissa. In West Bengal, that is the common practice now. That when police submit charge sheet, they submit multiple copies. But that was not mandated in the CRPC. They do it because to expedite the processes. Oh, case diary will come to you only, PP. No, sir, that is not the practice. They only submit one set of the copies. The rest of the copies are prepared by the court itself. Okay, so now the things is going to be changed because now it's a mandatory duty on the police to prepare the multiple copies to give to the court. So it will be immediately, it need to be distributed among the accused. Because what happened is earlier in West Bengal also, when it was prepared by the court, there is a many dates happened only for making copy. So when I earlier started my practice that point of time, 1 year, 2 years only in copying stage. So and if some lawyers want to make delay, they can arrange in copy department such a way that the copy will not come on time.
And that provision is also in CRPC, sir. The police will supply the number of copies as required to supply the accused. That provision is in CRPC, but that practice is not. No,
sir. Number of copies is not CRPC.
Yes, sir. The provision is there. No, sir.
207 requirement is the court to distribute the copy under 207.
170 perhaps, 170,
okay.
173. There
number of copies.
Number of copies.
Okay, I'm not sure. We need to just check it.
173. There is a provision, sir. According to the number of accused, the police
they'll give the copies.
Number of copies.
Okay, so now this is added here also. Okay, number of copies they will prepare. Okay. this is okay. We can go for the break, and thereafter we can discuss some more provision in the CRPC, because it still will take 15 half an hour more to finish CRPC part. The changes which we made in BNSS, so maybe another 15-20 minutes I will take in it, and then we'll go to BSA provisions. But it's important to look at all the changes which are there. We must know about these changes. So 336, very progressive provisions. I said earlier also about this, that many a time a public servant who transferred to other places or retired, sometimes these public servants are maybe just formal witnesses. So in those circumstances, their successor can come and give evidences. So there's no, earlier there was a provisions 293 for the scientific expert only. So instead of the director of CFSL, SFSL, list was there in 293. So some other staff, they can come and give evidences. Now they have a much broader section in 336 where they says, where any document or report prepared by a public servant, scientific expert, medical officer is purported to be used as evidence in any inquiry, trial or other proceeding under this Sanhita, and once such public servant, expert or officer is either transferred, retired or died, or such public servant, expert or officer cannot be found or is incapable of giving deposition, or securing presence of such public servant, expert or officer is likely to cause delay, then the court shall secure presence of successor officer of such public servant, expert or officer who is holding that post at the time of such depositions to give a deposition on such document or report. So very progressive provisions where the alternative persons can come and he can give evidences. So 336, a really good provision. 309, which was earlier, so basically day-to-day hearing, fast speedy trial concept. Now in clause 2, they have added that many times the lawyer get adjournment on the ground that something are beyond their control, and that's why they cannot appear. Some accused take advantage of it. So in those circumstances, when the court grant adjournment, it should not be more than twice during the trial. So the number of adjournment can be decreased. That's the whole idea, that unlimited number of adjournment cannot be there. So just to limit that, this provision is there. Then this is very significant provision. So again, new concept, new thing, new provision. Nothing was there in the CRPC earlier. Now, first time in the BNSS, we are introducing the concept of in absentia trial. So 299 CRPC is a specific limited circumstances which are there. So that so you can find in 205 also, 317 also. But completely in absentia trial, accused is absconded, you declare absconded, so proclaimed offender. So here he is not coming to the court, they will deem to be considered as present in the court. So there can be trial in absentia to the accused. This is completely new concept. That the court will do by photographs or something. So maybe CD photograph something will work out, because in absentia trial we started. Now we are not the first country in the world which do in absentia trial. There are many countries in the world which conduct this way, but definitely powerful democratic country, none of them do in absentia trial. So yes, yes, and there is some safeguards also. Like, so 2-time warrant has to be issued. You see the second clause too. Twice the warrant has been issued, published in the national newspapers, inform the family relatives that we are going to start the trial, affix informations about the commencement in the some conspicuous part of the home, court. So these are the safeguard definitely. Once we do all these, then court declared the trial will be conducted in absentia. For definitely proclaimed offender. So those who are, so proclaimed officer, court will declare. So court declare proclaimed offender. So after completing this formality, proclamation will be issued, and thereafter the trial can be conducted in absentia. If you search
Sir, in that provision, there is the provision of warrant, issuance of warrant twice within 30 days. It is mandatory
yes,
for procurement.
yes.
So why 2 times warrant to be executed conjugated for what within a 1 week?
Just to keep some weightage that we have tried our best. In fact, it is going to the same police station. Same police will give a report, he is not found. Again, second warrant, he will say he will not found. But at least you did 2 efforts you have made, and then the others, publication in the newspaper. So it's accused. So publication in the newspaper, and then affixing in the informing the relatives about the commencement of the trial, affixing the detail in the either conspicuous part of the home and the court, both. So once we observe them, declare them proclaimed offender, then the trial can be conducted in absentia. There are many interesting trials in the world. If you Google and search the trial of George Bush and Tony Blair on Iraq war, Malaysia has conducted their trial in absentia, given him both of them punishment. Do Malaysia has power to bring them? So George Bush is convicted, Tony Blair is convicted for Iraq war. Trial was in absentia. So we are not the first country. There are many countries in the world which follow this. In neighboring country, Bangladesh, there are many people who even executed out of in absentia trial. So order was passed, subsequently found, and the execution was done. So we are first thing we are starting the new concept completely in India. What will be the outcome? Let's see how the judiciary react to in absentia trial. So these are the safeguards which are provided with that. Okay, we follow all the efforts to bring the person before the court for the trial, and if even then if he is not absent, trial can be conducted in absentia. Clause 3, the proclaimed offender.
Sir, regarding obtaining of warrant for second time within 15 days, because the condition precedent is within 30 days we have to
Twice warrant.
twice 2 consecutive warrants. So for the second warrant, so what are the circumstances to justify before the court to get the second warrant?
First warrant is not executed, not found. So we ask for report now from police. Police will give the report that a person is not found. Yeah.
Clause 2 first time.
Interval of at least 30 days.
Sir.
So minimum 30 days. Minimum 30 days in the intervals. So after 30 days, expiry of 30 days. Interval 30. So 30 days gaps, then you can issue. So that's warrant can be issued. So court normally issue warrant. Now advocate need to be given. So court will appoint from the legal aid advocate, etc. if he is not being found. Where the court competent to try the case or commit the trial has examined any witnesses for prosecution and recorded their deposition, sub-deposition shall be given in evidence against such proclaimed offender on the inquiry into or in trial for the offence which he is charged, provided that if the proclaimed offender is arrested and produced appear before the court during such trial, the court may, in the interest of justice, allow him to examine any evidence which have been taken in his absence. So that's the one remedy is given, that in between he appear. Then in those circumstances, the witness which are being examined, give him opportunity to examine them. So basically cross-examine them. Where a trial is related to persons under this section, the deposition and the examination of the witness may, as far as practicable, be recorded by audio, video, electronic means, preferably mobile phone, and such recording shall be kept in such manner as the court may direct. So, entire evidence trial has to be videographed. In prosecution of the offence under this Sanhita, voluntarily absence of the accused after the trial has commenced under subsection 1 shall not prevent continuing the trial, including the pronouncement of judgment, even if he is arrested and produce or appear at the conclusion of such trial. So might be appear and then suddenly disappear. The same process, declare them proclaimed, and then the trial can be in absentia. Same process, sir. Same process. Because that's what happened in proclaimed offender. Like, what is proclamation? The CRPC has provided the same here 4 process to bring someone before the court. Easiest is summon, little difficult warrant, then proclamation, then attachment. So the same process will be followed by whether it's a one time or twice or thrice. The process need to follow.
But the trial court, before the commitment, suppose the accused has not appeared, so he will not be committed to the court of committed court, to the sessions court for his trial. So once the accused has not committed, so the trial court will declare again the proclaimed offender, and he will be, after declaration of proclaimed offender by the trial court, then the absentia trial will be there. But till then there is no registration regarding his name in the sessions trial case, because he has not been committed.
Now the commitment the lower court will do, so they can commit without even this. Commitment will be done now. So it's because of the court will decide, trial court will decide. In absentia. Now, even these proclamations under the present provisions also, even before commitment, 5 accused are appearing, 2 accused are not appearing. So commitments are held, 207 is not being complied with, so waiting period.
In this chapter, sir, this new section, the first one says that he is not a member of the group, individual of the group. That is the first.
No, it's a group also, sir.
Whether or not charged jointly.
So it may be single and jointly, na? Both it can be. Because no, where it says, notwithstanding anything contained in this Sanhita or in any other law for the time being in force, when a person is declared as a proclaimed offender, whether or not charged jointly, so even whether charged singly or charged jointly, both applicable, na, sir, has absconded to evade trial and there is no immediate prospect of arresting him, it shall be deemed to operate as a waiver of the rights of such person to be present and tried in persons, and the court shall, after recording reasons in writing in the interest of justice, proceed with the trial in the like manner and with like effect as if he was present under this Sanhita and pronounce the judgment.
Yes, sir, doubt is that.
Yes.
So far as the 209 CRPC was concerned, at the time,
Commitment.
The magistrate committed the accused, as well as he was sending the record to the sessions court.
Committal code has no power, sir. If you go through the proviso, sir, it is written that provided that the court shall not commence the trial, only trial. So charge is excluded unless a period of 90 days has been lapsed from the date of framing the charge. So there must be a precondition is that charge is framed. After that, this application, this provision. That is the only court, trial court.
No.
Oh, that the provision called like
No, sir, first point is, sir, after registration of case, charge sheet submitted.
Yes.
Now the accused is not there. So accused, the police declared as a proclaimed offender by taking the order of the court and accordingly submitted charge sheet against a accused who is not apprehended during course of investigation.
Yes.
Now, sir, it is the duty of the magistrate to commit the case to the court, to the trial court, and what is that procedure? Where is that procedure, sir?
जदि से पठेला
They-
कोन
they-
चार्ज
they
हे
will-
परिबो कि
They will proceed with the trial. Just 1 minute.
एडी कहला प्रोविजर कोन कहला from the date of framing charge
There is a charge of, in absence, there will be charge.
from the date of framing the charge one
If he was present, as if he was committal
Okay.
Clear in one fourth line.
Yes,
That
sir.
proceed with the trial in the like manner and with the like effect as he was present. Proceed with the trial. Everything
they
will
will
be there
proceed-
in again. Say through interpret college.
Okay. 209 is 232 under the new law. So 232 number, and 232 says, when in a case instituted on police report or otherwise, the accused appears or is brought before the magistrate, and it's appeared to the magistrate that the offence is triable exclusively by court of session, he shall commit after complying with the provision of 230, which is basically 207 or section 231, the case to court of session and subject to provisions of the Sanhita relating to bail, remand, etc. Subject to provision of Sanhita relating to bail, remand, the accused to custody during and until conclusion of the trial, send to the court the record of the case, notify to the public prosecutor comment of the case to the court of session. So nothing has been said there in 232, provided that there are two provisions, that the proceedings under this section shall be completed within a period of 90 days from the date of cognizance, and such period may be extended by the magistrate for a period not exceeding 180 days from the reasons to be recorded in writing. So the commitment has to be completed within 90 days or maximum with reasons 180 days. Provide further that any application filed by the magistrate by the accused or the victims or any persons authorized by such persons in the case triable by court of session shall be forwarded to the court of sessions with the committal of the case. So it has not said anything in regard to in absentia accused. After committal, he is absented. Yeah. So, no, but
Question of charge will arise after appearance or declaration that his absence is waived. His presence is waived. If the court passes an order that his presence is waived, then court will frame charge.
So it implies that commitment proceeding.
that is sir after the date of charge that is sir you just see sir subsection 1 subsection 1 of second line
Ji.
has absconded to evade the trial has not commenced. So that means the charge, the record is posted for charge. Then that is applicable.
After charge.
So if you take trial includes charge, framing of charge, then only that is applicable. After
Absconded.
so that is during trial.
এটা স্যার ডিলে ট্রায়াল ପାଇଁ କି এটা ହେଇଛି
So let's see how it goes. But then even when we do commitment, at the stage of commitment also court issue proclamation. Before that also they can court has a power, because all these 4 processes can be applied, because even the split happened that point of time also. So let's see how it goes. But court may give protection. Now this 398 new section which says about the witness protection scheme.
subsection 7 টা স্যার the previous section
No appeal.
sir if the accused, in absence of the accused, the trial conducted and ended in acquittal, then state can go for appeal or not?
No appeal. Yes, no appeal from either side.
No, the state can go appeal. That is not applicable. This is applicable in respect of accused, because accused was not present. The state was present.
No appeal shall lie against the judgment under this section unless the proclaimed offender present himself before the court for appeal. It's a specific
It is for the accused, because no, state appeal power is not from here. State appeal for the appeal section. State appeal power is from the appeal chapter where the appeal provision is there. This is an exception for the accused, that okay, if accused want to take advantage of that appeal provision, he has to be physically present. So he was absconding, it is for the accused. Provided that no appeal against the convictions shall lie after the expiry of 3 years from the date of judgment. So again, restrictions, no appeal to the accused. Now this may sometime court may let's see, judicial review is a part of basic structure. So might be tomorrow court will say that we can take judicial review.
Yes.
Yeah. So witness protection scheme, again the state government has to make the witness protection scheme. Mercy petitions in the death sentences, they fix the time limit within which the accused will have to submit the mercy petition application. So 30 days or so within a period of 30 days from the date of the which the superintendent of jail inform him about the dismissals of appeal, review, special leave, or appeal to Supreme Court, inform him about the date of confirmation of the sentence by death. So within 30 days he has to file applications. The petition under subsection 1 may initially made to the governor, and on its rejections or disposal by the governor, the petition shall be made to president within a period of 60 days. So within 30 days, the application has to be made to the governor, and within 60 days, the application has to be made to president. So that's the time limit which has been fixed here. But then there is no fixed time limit for the president or governor to dispose of. So even not under constitution. The procedures which are there, we don't need to go into the procedures. Earlier, which was 436A. So if the under trial prisoners who are there in the jail, so it was said after half of the period, the persons may be enlarged on bail by the court. Now it says 1/3 period for the first time offender. So there is a new thing has been added. For the first time offender, if the person is there in jail for 1/3 of the period, then in those circumstances, court may enlarge on bail. Directions for grant of bail to the persons, 438 basically, anticipatory bail. The 2 clauses which was there, that 2 clauses, first the some condition was there, and other clauses the accused need to, subsequent amendment where the accused need to be present. So language has been changed in 438 little bit. So 438 under new law, it's become 482. So 482, directions for grant of bail to the person apprehending and So earlier in CRPC 438, there was a 1A, 1B where the basically gravity of the offenses, etc. Those countries consideration were there. Those part has been omitted. 438 is a mini state amendment. One A, which says nature and gravity of the offense, antecedent, possibility of justice, accusation. So this part which was their consideration of the gravity, that part has been omitted. So what was the original provision that has been brought back? And 1B, which was added subsequently, 1A, 1B, interim part was there. Then the order to be public prosecutor, but some other thing has been added for the prosecutor. So some changes have been there for prosecutor. So they bring the original position of 438 anticipatory bail, the same thing they have brought in the new law. 530, trial and proceedings to be held by electronic modes. So the general provisions for all kinds of trial. So all trial, inquiries, proceeding under this Sanhita, including issuance of service, execution of summon, warrant, examination of complainant and witnesses, recording of evidence, inquiries and trial, all appellate proceedings or any other proceeding may be held in electronic mode by use of electronic communication or use of audio, video, electronic means. So now all trial, all proceedings can be conducted by electronic audio, video, electric means under 530 of the Act. What are the other changes? 479 that we have already discussed, 1/3 of imprisonment for first time offender. Time limit. So discharge application which was there under section 250 within 60 days of committal. So either they have to frame the charge or discharge. 251 within 60 days of hearing, acquittal or conviction. 258 within 3 to 45 days of completion of argument, the judgment has to be given. Trial has to be on day-to-day basis and condition granting adjournment. Noise category says only twice adjournment during entire trial on the ground which is beyond the control of the accused. So twice only the adjournment can be there. That's what this section specifically says. Then it also says recording of the witness, public servant, depositions by electronic, audio, video, electronic means under 254. We discussed that. All trial, inquiries, proceeding may be held through electronic mode, 530. Evidence for the committed outside India can be received in electronic form from 209. So anyone by audio, video means they can give evidences. Evidence of the public servant, etc. can call successor in office. We discussed 336. Inquiries, trial, judgment in absentia of proclaimed offender, 356. State government obligated to prepare and notify witness protection scheme. Mercy petitions, timelines are there, 30 days and 60 days. 30 days, within 30 days to governor and within 60 days to the president. Summary trial, earlier it was say may, in some cases theft, etc. Now it is used the word shall. So in those smaller theft, etc. which are mentioned there, mandatorily summary trial. That's the provisions are there. Plea bargaining within 30 days of framing of the charges. So any application of plea bargaining shall be made within 30 days of the framing of the charge. That basically all changes in the BNSS which are there. I was supposed to discuss on the session trial, warrant trial, summary trial, but there is no significant changes. So the process which are there, all the same procedures are there. So I deliberately focus on what are the changes are there, because you all know the CRPC, how it is being functions. So wherever the changes are there, I did explain to you. Yes, sir. It will be conducted by assistant session judge in the same manner in the old law. So nothing will change for them. So that's why all the application trial which are pending. They will conduct it in the same manner. Under the, no changes, under the old law. So that means the court has to follow both the law, old law, new law. So all old cases, it will follow the same thing. I'm reading the last section of the new act. BNSS last section is section 531, which is repeal clause. So first word says CRPC hereby repealed. Clause 2 says, notwithstanding such repeal, if immediately before the date on which the Sanhita came into force, there is any appeal, application, trial, inquiry, or investigation pending, then such appeal, application, trial, inquiry, or investigation shall be disposed of, continued, held, or made as the case may be in accordance with the provision of CRPC as in force immediately before such commencement, hereinafter referred to the said code, as if this Sanhita has not come into force. For those cases, this Sanhita has not come into force. It will follow the CRPC. Yes, sir. Yes, sir. That's the CRPC. 530. 531, sorry, sir. 531.
Saving clause.
Last section.
Notifications relating to state central government.
Ha.
Not
Don't-
state government notification.
No, state can make state amendment, but that again has to go to the, according to constitution, it has to go to the president for ratifications, and then only it will be
No,
enforced.
retrospective effect नहीं है वो.
No.
Notifications, sir, notifications regarding corresponding section of old law
Ha.
of the state government is not applicable to the BNSS.
No.
That means all the new notifications will be made for execution of a BNSS.
All the new cases from 1st of July, it will be governed BNSS. All cases which were pending till 30th June, all those cases will be governed by CRPC.
No, sir, in 530, all notifications, my point is all notification means these notifications of the central government will prevail regarding the old law. Notifications is there. What the word?
In 530.
Last section, saving clause, sir. Saving section does. The saving section.
Ha. Notification that the center, now to central government will give notification, na.
That means
Now to central government will give notification wherever the state government has power. For example, state has to frame the rules for witness protection scheme. That state government will notify. Or in some places where the state has to frame rules, the rules will be notified by the state government. So depending on the power, some places the power is vested with the state government, some places power is vested with the central government. For the applicability to central government, in future, might be the state make some amendment. In those circumstances, those amendments will be applicable by state notification because it has to be by the own process. So it is the law which is fall in the your concurrent list. Both state and union has a subject matter. So state can make amendment to it. But that amendment require, according to constitution, ratification from the president. So it will go to the president for ratification. If the president approve, then for the Odisha, that law will applicable. So that will be notified by the state government.
Sir, I have a doubt, sir.
Yes, sir. Good.
So as far as this repeal clause is concerned, sir, that application is pending before the copy section regarding revision or appeal.
Sir.
In between, July 1st came. So now I have certain time as far as the Limitation Act is concerned to prefer appeal or revision.
Yes.
In fact, I have not preferred the appeal or revision. Now, in between this appeal clause will apply from 1st July. In that cases, what we will do, sir? What is the meaning and I mean, what the prosecutor will do?
Those cases, appeal revision will be governed by the CRPC provision if the permit it will be a law. If not permitted, it's not a law. So whatever the
No, as
time
far
limit
as,
are there.
the term that is used as appeal. In fact, in case, that case, in a particular case, I have not made an appeal from the state.
No, but sir, all like basic rule, what's the idea is, might be,
Huh?
did they have not used the word revision? Old law will apply, na? Sir, these are the language thing, might be it's all happened because the drafting process very fast they conducted draft. So they have not used the word revision here, but the appeal do include the, in this case, for this purpose, revision also.
No, no, sir, I am saying that, sir, that is regarding time.
Whatever I ever read, if the limitation has expired, so far as the CRPC is concerned, BNSS Act will not revive it.
No,
That provision is clear, sir. If limitation has expired, under old act, then that will prevail. The new act, under BNSS, no bar limitation will be allowed to be worked.
no, whether it's have limitations or not, whether to condone limitations or not, everything has to be decided keeping in mind the CRPC provisions and their precedents. So there are precedents of CRPC that will be followed. Sanita has nothing to do with those cases which are pending. Or even if the appeal is like not preferred, but if appeals are basically continuation of the trial.
Right, sir.
So that will consider same way, no, sir. Okay, now we comes to your provisions on BSA, Bharatiya Sakshi Adhiniyam. Now, luckily, sir, BNSS, anyone has any other questions? So all the changes is clear to you. So what are the changes which have been brought in the law? By in practice only you can solve it. Because when the challenges will come, the court will interpret. Okay. Now we come to the Bharatiya Sakshi Adhiniyam, BSA, which is basically replica of Indian Evidence Act. Now, when we talk about the this Bharatiya Sakshi Adhiniyam, this is one law which not being amended very frequently. So you will find that when this Indian Evidence Act came, we had a different criminal procedure, and there are 3 changes, smaller changes multiple times. IPC also multiple changes, but in evidence law, from 1872 till now, it is working well. And that's the reason that Evidence Act, we only found changes which happened of 2 categories. Whatever changes there from 1872 till now, only 2 categories. One, when the digital evidence came, there are changes to recognize digital evidences. So there's a large number of sections, changes are being made. Second, depending on the societal need, presumption clause has been added to shift the burden on the accused. So you'll find all the changes under the evidence law is fall only these 2 categories. One where they added the presumption clause, might be in different time, but they added presumption clause, and other IT evidences has been added. Nothing other apart from that, we don't find any changes in the evidence law from 1872. Even when we got this new law today, we find the similar scenario. These are least number of changes which are there under the evidence law. So BSA, Bharatiya Sakshi Adhiniyam, you will find the least number of changes in the act. The place where there is a major changes among those least number of changes is on the digital evidence. So digital evidences, there are significant changes are there, and some of the things which we'll discuss in the first part, like cassette, etc. We'll see this clarity in the when we talk about the digital evidence under the new law. So let me see what are the changes which are there under the Indian Evidence Act, Bharatiya Sakshi Adhiniyam. So when we see some of the things, I will just skip. I don't need to go into much detail of it. We all know what is evidence, why evidence has a structure. But I do want to discuss the structure a little bit because evidence we always comes into questions in the court, and there's a need for clarity in some circumstances. When we say evidence law or even BSA Bharati Sakshya Adhiniyam, we use the word it is a usual means of proving or disproving a fact under inquiries or trial. Why we use the usual means? Because there are other things also which helps in proving or disproving the fact in the court. So, and that's the reason these are the things which Evidence Act has talked about: facts in issue, relevant, admissible. We'll discuss that from time to time. Some of the best evidence rules are there. That also we will discuss about the best evidence and basic principles which are there. But what we wanted to say is, let me see. No, not document. Okay. So we say evidence is a usual means of proving or disproving the fact. That means there are other means. What are those other means? Other means could be your presumption. It could be something otherwise also. Demeanor under the CRPC, 280 CRPC says the judge shall record the demeanor of a witnesses. Why the court will record if they will not take into account? The court can take into account. Presumption court take into account, but these are not evidence per se. So court talk about facts in issue, relevant fact, admissible, what may be proved, what may not be proved, what kind of evidence may be given, who are going to produce those evidences, how those evidences can be given. All these things we find which are mentioned under the evidence law. There are some basic rules of evidence which are there, and we in all circumstances we need to remember this basic rule of evidence. What are those basic rule of evidence which we need to remember? The first rule which we normally say, best evidence must be given. Now, when we say best evidence given, it can be best evidence in terms of oral, best evidence in terms of documentary. So in oral, direct evidence are best evidence, hearsay are not best evidence. Documentary, primary are the better evidence than the secondary evidences. So depending on the circumstances, we normally give best available evidences, whatever available at the relevant circumstances. Hearsay evidence not admissible. As a general rule, there might be exception. Evidence may be given of facts in issue and relevant fact. Now this section 3, which was earlier section 5. So section 5 says what evidence you can give. Now this section, because of this, the value of entire relevancy part increases. Because this section 3 or in the old Act section 5, it says what evidence you can give. And it says you can give facts in issue, you can give relevant fact. It does not stop there. Had it stopped there, then court could have interpreted this is illustrative. Court says there can be other thing also which can be relevant. Then it says comma and of no other. So if you see section 3 in the old Act section 5, at the end comma and of no other, which means that you cannot give any other fact other than the relevant fact. And relevant, not what you think relevant. Relevant as has been declared relevant hereinafter. So under new Act section 4 to 50, under the old Act section 6 to, so 5 is start, section 6 to 55. So it has to be relevant within those sections of the Act, then only admissible, otherwise it not be admissible. All fact except the content of the document may be proved by oral evidence. Again, general principles. When few months back, this in Delhi, all wrestlers were agitating against the president of this wrestlers association on the allegation of the sexual harassment, etc. We find some comment here and there by even police officials at that point of time. No evidence available. What evidence? Basic rule, every fact under the sky can be proved by oral evidence except content of the document. So other than the document, everything can be proved by oral evidences. If a girl gives statement about some harassment, evidence. If some other girl says, no, I have seen it, corroborative and corroborate and increase liability. All fact except the content of document may be proved by oral evidence. Fact judicial noticeable need not be proved. Basic principle in part 2. So earlier it was section 56 and 57. Under the new act it is 51 and 52. Fact admitted need not be proved. Under the new act it is 53. Earlier it was 58. Oral evidence must be direct. Again, basic principles. Now, what are the changes which are there in the act? So, one changes which are there is, remember in the Evidence Act, section 2 was repealed clause. So, there is no section 2. So, definition was in section 3 and section 4. 4 has defined may presume, shall presume, conclusive proof. And other definition we find in section 3. So, both section 3 and section 2 merge in one section, section 2 now. So, under the new act, section 2 is a definition clause. In the old act, the old act has been divided into 3 parts. Part 1 start from 5 to 55, relevancy of the fact. Part 2 from 56 to 100, and the part 3 from 101 to 167. So, initial 4 section 1, 2, 3, 4 was used the word preliminary in the last act. These are the preliminary provisions. In the new act, section 1 and section 2 has been declared as part 1. So basically they are preliminary, but in the act they says part 1 means section 1 and section 2. Section 1 is the title section, section 2 is a definition clause. So what was part 1 earlier become part 2, what was part 2 earlier become part 3, what was part 3 earlier become part 4 now under the new act. So that is the structural changes in the act. Section 1 clause 2, which is basically applicability clause, it is much refined. Earlier you will find applicable in the Army Act, Navy Act, Air Force Act, very detailed provision was there. Now it simply says it applies to all judicial proceeding or before any court, including court martial. And it's not applied to affidavit, which was there earlier also, or to arbitrations. There are other laws also where evidence act does not apply. Lok Adalat does not apply. Mediation does not apply. So there are many things where it may not apply in some circumstances. But even in those places where it does not apply, the principle of evidence act apply. So even departmental proceeding, evidence does not apply. But principle of evidence law, which got the status of natural justice, do apply in those proceedings also. Okay, what was deleted and the rightly deleted? Section 3, the definition J, which was the definition of India, has no use today. Our border are settled, might be having confusion when the earlier date was there. So now it has been deleted. Section 82, presumption as to document admissible in England, no use today, deleted. 88, it had some use, I don't know why I have deleted. There are some other sections to cover it. 113, a proof of the cession of the territory, again no need. Our territories are settled, so deleted. Jury trial, we don't have any jury trial, so 166 deleted. So these are the sections which was there under the Indian Evidence Act. They are all deleted under the new law. Under the BSA, these laws are not there. Then we come to the definition clause. First, the definition of document. Wherever you will find in the Evidence Act, they use the word electronic record earlier. In every place, electronic record has replaced with electronic and detailed record or electronic or detailed record. So some places electronic and digital, some places electronic or digital. So throughout the Evidence Act, they have used the word. My impression is this inclusion of detail only for the purpose of clarity, so that any lawyer tomorrow not argue that look, this evidence is electronic and not digital, or this evidence is digital and not electronic. So no one can argue this, and that's why they wanted to make clear that all these forms of evidence can be covered here, electronic or digital, electronic and digital, that's what has been used. Another change here is there in the beginning second line, or otherwise recorded. This was not there. Earlier it was there, means any matter expressed or described or recorded upon any substance. Otherwise was not there. So now by using the word otherwise, again ambit increases. By any means it is recorded. Those are the documentary definitions. Just think about the earlier cases. In 60s, a very famous case called Yusuf Ali versus State, where the issue arises with a tape recorder cassette, is it a document? And the Supreme Court says, when there is a tape recorder cassette, someone is speaking, their voice are inscribed. So the tape is a substance, voice is inscribed because it says recorded upon on any substance, says tape recorder is a document. We can take same chronologically, whatever manner something is recorded in any instrument, they are document for the purpose of this act. So that's the very clear definition which the act has says. Illustration 1 to 5 was earlier, the same illustration remained there, so I don't want to discuss that. Illustration 6 has been added, it's a new illustration. It is added for the purpose of detailed evidence. So it says an electronic record on email server, log, document on computer, laptop, smartphone, messages, website location, voicemail messages, store on digital device are documents. So all these electronic things, whatever manner some things are recorded, they are all considered as documentary evidence. By the use of what otherwise recorded, the ambit has increased. So it's much wider now from the earlier. So whatever manner something is recorded, now everything becomes digital now, or like smart. You buy air fryer at home, smart air fryer, smart TV, you have a smart refrigerator, you have a dishwasher smart, cleaning things smart. Everyone has a memory chips. It contains data. How many minutes they have used in the home, everything information can be revealed. What are those? All are document. So whatever manner it is recorded, otherwise recorded, they are all document for that purposes. So that's why using the broader word of otherwise is cover all the aspects. They are all document for the purpose of this act. Now, this is the definition of electronic record. Electronic record has not been defined in the Indian Evidence Act, nor under the BNS Sakshadhaniyam, BSA. It is defined in the Information Technology Act. And when we see the definition of electronic evidence, electronic record, you see the wording: data record, data generated, image, sound store, received, sent in electronic form, macrofilm, computer generated macrofilm, macrofiche. Anything under the sky that cover here. Now here first what is data? They have defined data also. Just see the look of data. Anything which represent whatever detail manner might be, wherever it might be, all those things are data. So even when this digital word was not there in the document definition, in the reality, all the digital evidence, everything which was in the digital form, it do come in the ambit of electronic record. So that's why I said by using this word digital, it basically a clarity. It gives clarity that no one can argue that look, this is not electronic record, this is digital. So that's for that purpose they have added it. It also, IT Act also defines communication device, means any phone, personal or see any other device. Why they use other device at that point of time? We don't know tomorrow what kind of device will develop. We never thought of that if we put in a CCTV camera in our home, it can use a communication device. Now I can open the apps with the CCTV in my hall room, and if I see some person, I can say by mobile I can talk to them through that CCTV. So the CCTV become communication device. We communicate. Watch become communication device. So tomorrow we don't know what are the things which can become communication device, and that's when we read other devices or any other devices which used for the purpose of communications. So it do cover all those aspects under the Act. So IT Act was defined. Computer they have defined, computer system they have defined. Now we come the definition of evidence. Now in the evidence definitions, earlier it was the same, some minor changes are there. So earlier also the evidence definition in two parts, oral evidence, documentary evidence. Now in the oral evidence they have added a statement including a statement given electronically. So now when the people give by audio, video, electronic means by video conferencing, those also considered as oral evidence. Remember that first time when the Supreme Court in the case name Dr. Prafulla B. Desai, where the Supreme Court says that when we do by video recording and when the screen his photo appear, it is as good as their physical presence in the courtroom. That was the interpretation of the Supreme Court in the Prafulla B. Desai case. So if they appear in the screen, it is as good as physical presence in the courtroom. So considering that when a person's give by audio video means these are oral evidence, that's the first part. And second is documentary, which include electronic or digital record. So digital word has been added recently. But again we say, yes sir, and given by video conferencing is evidence. So court says when he's appear in the screen, it is good in presence in the court. So and thereafter the amendment came in the CRPC also, where the by video conferencing it can be done. Now evidence definition in the Evidence Act we say is narrow definition. Why is it narrow? It's only talk about two categories of thing, oral and documentary, and it does not take into account other things which are the material evidence, physical evidences, etc. They are not evidence in the strict meaning of the Act. We call them evidence in the court, but they are not in the real sense evidence as per this definition. So that's why we say the definition which are there is narrow in nature. So when they are not as evidence, how they go to the court? Two places are there, 160, but the main thing is when we see the definition of proved. Proved definition says after considering matter before it, it means court. So what the court consider matter? What kind of matter? Matter can be documentary, evidentiary, it can be non-evidentiary. When it is evidentiary, oral and documentary. When it is non-evidentiary, it can be any other thing. Judicial notice, demeanor, presumption, all these are non-evidentiary matter. These are not real sense evidence, physical evidence, other material evidences, all those things which are there. Okay, clause 2 of section 2, they refer to BNSS. Earlier it was used to CRPC or IPC. This is the three component. It's not basically Indian Evidence Act, it is BSA, Bharatiya Sakshi Adhiniyam. Indian Evidence Act, it was first was 5 to 55, then 56 to 100, and then 101 to 167. So in new act, again three part. So leave first part is section 1 and 2, we are leaving it. Other is divided into three components. So beautifully it has three part, three compartment in which the entire act is being divided. First compartment is relevancy, essential compartment. If not relevant, not admissible. Second part, on proof quality of evidences by which we prove this relevant fact. And the third part is all court power, essential things, witnesses, examination of witnesses, estoppel, court power, improper admission and rejection, what will happen at that point of time. So all those things we'll find in the last part of the act. Relevancy of fact, we all know, I'm not going to detail of it. Section 3, I said earlier, why this relevancy is important? Because in section 3 it says evidence may be given in any suit or proceeding of existence or non-existence of every facts in issue. So facts in issue always relevant, comma, and such other fact which are hereinafter declared relevant. So not that what you think relevant, only those relevant which are declared relevant hereinafter. That means section 4 onwards, 4 to 50, and comma, and of no other. So other thing will not be admissible. Because of this use of word and of no other, the value of this relevancy part enormously increase. So it has to be relevant in some section of the act. So when we look at the relevancy, these are the structure. You all know, so I don't need to go into very detail of it. So first part of relevancy 3 to 14, which is called general relevancy. A large number of evidence comes within this only. Then 15 to 25, admission and confession. Earlier it was 17 to 31. Statement by the persons who cannot be called as a witness. Earlier it was 32 and 33. Statement made under special circumstances. Earlier it was 34 to 39. Now 28 to 33. Judgment of the court 34 to 39. Earlier it was 40 to 44. Opinion 39 to 45. Earlier it was 45 to 51. And the last part is character evidences. Earlier it was 52 to 55. And now it is 46 to 50. So that's the structure. Now, what are the changes which has been made in the evidence law? First part, in the relevancy part, there is a merger. So we all know 24, 28, 29. 24, confession obtained by inducement, threat, promise, irrelevant. 28, as soon as that inducement, threat, promise withdrawn, confession made thereafter are admissible. 29, confession barely some promise was made for privacy or confidentiality, it will not have any impact, it will be admissible. Confession is admissible. Now these three sections 24, 28, 29 now become one section 22. So 22 clause 1, 24, then 28 is a proviso, 29 is proviso. Similarly, the three sections again which are relating to police, 25, 26, 27, confession made to police officer, inadmissible. 26, confession made while in police custody, inadmissible. 27, if the statement helps in discovery, irrespective of confession or not, admissible. So 24, 25, 26, 27. These three become now 23. Again, it become one section, section 23. So these are the merger of the section. Different section has been merged together. Now we come to section 45 and 45A. Again, they merged together. 45 we all know opinion evidence. Sir, it's not only experts, sir. There are other also in opinion evidence when we say, yeah. So there in 45 is expert, but like different categories which has been said there. Other section has the other opinion also. So 45, 45A become now 39. 45A was about detailed evidence, their opinion. That become 45A, 39. 47, 47A, handwriting. Who is acquainted with the handwriting? So that 47 and 47A was detailed signature. So both now merge and become one section, section 41. What are the other changes? First section of relevancy. Old law, it was section 6, new law, section 4. We call it sometime in Latin res gesta, part of same transaction. Now remember, only 3 words has been added here, 4 words, or a relevant fact. But because of this add of 4 words, this section ambit has been enormously increased. Earlier, when we used to say connected fact, we used to only say the fact connected with facts in issue. Now, under the new law, the connected fact which are either connected with facts in issue or connected with relevant fact. Now, relevant fact is enormous, up to section 50. So, the section 4, the first section itself is an enormous increase the relevancy part. Is it not, sir? When you take evidences in the court, anything which are directly connected with the facts in issue, relevant, but connected fact. Any fact which are connected with the other relevant fact, that are also relevant under 4. So it is enormously, exponentially, it has been increased. The scope becomes much wider. What was there earlier? So only 4 words has been used, but is the potential is enormous under section 4. Other changes. So inclusion of or a relevant fact, it has made the additions broaden the scope of the connected fact. In fact, remember section 6 earlier, now section 4, which we call res gesta, it is also considered as exceptions to hearsay rule. Because many situations, hearsay evidence can also be admissible under section 6. In some situations which are there, which are corrected fact, if it is spontaneous reaction, instantaneous reaction, immediate reaction. Now they have included which are connected to relevant fact also. So in the similar situation, if it is spontaneous reaction, instantaneous reaction, immediate reactions there, it can go in the evidence. The scope is much more wider because of this use of this word in the section 4. So relevancy scope has been extended enormously. Okay, this is section 22, which basically earlier 24, 28, 29. Now, do you find any changes in the title, any new word you find there, which was not there earlier in 24? Just title, first few words are there. You find any new word there? Sir?
Which section, sir?
It is section 24. 24 become 24, 28, 29. That become 22. So this is 22. Any new word you are finding in the heading, which was not there? Coercion. Was coercion there earlier? No. Earlier it says inducement, threat, promise. Now they have used the word coercion. Coercion has been defined in Contract Act. It do use in the criminal cases also. So the again here the ambit is wider, but this ambit is for the protection of citizen. Many situations, even if the coercion when is not there, it do cover within the ambit of threat. So coercions can, like threat can cover coercion also in many situations, but now they have used it coercion also. So the coercion word has been used. So that's the one change which are there. So it's in 24. So 24, 28, 29 become 22. The same thing. So section comes here. So old sections, where old section only inducement, threat or promise were mentioned as factor affecting the relevancy of the confessions. The new sections explicitly include coercion as a factor, broadening the scope, providing more comprehensive coverage. This is 23, which is basically 25, 26, 27. So what was 25 become clause 1 of 23. What was 26 become clause 2 of 23. What was 27 become proviso of 23. So the same section, nothing changes, no new section. What 3 section has merged in one places. Now this is section what was earlier section 30. Now become 24. Now 30 we all know is a joint trial, co-accused confessions, approver confessions, etc. There is no changes till explanation 1. What was there? That is same thing is here. What is the new has been added is explanation 2. And this explanation 2 is keeping in mind, remember BNSS we have seen 356 absconding trial. So here they says that even if the trial is conducted in absentia, it will be deemed to be considered as joint trial, because those co-accused confessions can be used against the person who is absconding. So it will be considered as a joint trial for them also. So very clear. So wording stuff is very clear. So that can be used against the co-accused. So deliberately keep in mind those in absentia trial, they have brought this section of the co-accused. Okay. Illustration is the same, we don't require. So in absentia trial 356 we don't need to see, we have seen already in BNSS. There are some changes which are some minor words are changes, like in section 32 books published either, like earlier it was the published in the book format, now it says electronic format also. So opinion of the books etc, all those can be relevant. So those changes are there. When the court has to form an opinion on the point of foreign law science, we have seen 45 and 45A. Thus the section number has changed. So 45 become 39 clause 1, 45A become 39 clause 2, nothing else. The same language, nothing else. So nothing much to discuss there. Electronic signature or other signature are relevant. So what was 47 become 41 clause 1, what was 47A become 41 clause 2. So that's the section, just a merger or amalgamation of both of them, nothing new specific there. Okay, that basically these are the changes which are there in part 1. There we don't find any much changes in the part 1. The remaining part we can look at after tea break, I think so 3:30. Now first series section says fact need not be proved. So basically one is judicial noticeable fact 56, 57, and 58 says about the in the old law, and 51, 52 in the new law, 53 admitted fact need not be proved. So all other facts need to be proved. So these are the basically all the division which are there. So fact need not be proved 51 to 53, oral evidence 54, 55. Now you see the for oral evidence only 2 sections, and the remaining are for the documentary evidence. So the more requirement, more clarity, more specific provisions we find for the documentary evidence in the Evidence Act. So general document 56 to 73, then the public or private 74, 78, presumption as to document 79 to 93, and then the last part exclusion of oral evidence by documentary evidence 94 to 103. This is the basically the entire structure of this part of the evidence law. Now, what are the changes which has been brought in? Now, first changes we see in this part is in section 57 earlier, which was basically the court can take judicial notice. There is a list, long list was given there. Something were redundant. So, like the Code of England, Seal of Code of England, all those were not required. And accordingly, now we find much clean provision. So, 53, those part has been deleted, and the remaining, the same thing what was there has been incorporated in 52. So, we don't see something new, but basically it is much more improved version of 57. So, 52, that the changes are there. There is a very major changes is in respect of the definition of primary evidence. There are some changes in respect to the definition of secondary evidence. On digital evidence, section 61 has been added. It's a new section. What was earlier 65B, so which where we always say certification process, etc. What was there, that becomes section 63. Section 74 and 75 that merged together become one section 74. I think 74 is the only section which was last act also it was a public document, new act also is public document. All other section number has changed, but only public document section is same what was in the previous law and the new law. So earlier it was 74, in new law also it is 74. So these are the changes which we find in the new act, and let me see little more detail in those definition. So I said that one of the major changes which we find in the new act is the definition of primary evidence. Now primary, this part, it's old, same thing is there, so I don't need to devote time on it. So explanation 1, explanation 2, explanation 3, primary evidence is the same thing what was there. Now we come to what is new. So the new is 4 explanation has been added. Explanation 4, explanation 5, explanation 6, explanation 7. So 4 explanation has been added in the provision of primary evidence. Let me see first explanation, explanation 4. It is basically whenever we record something digitally, whether that recording happened simultaneously or subsequently. So like suppose if we record in mobile or he is recording in the camera, the file which is saving depending on the system, it might be that every hour a new file is generated and it is being saved. Temporary file also being created by which. So whether it is saved simultaneously, whether saved sequentially, whatever it might be, they are all primary evidence. So that's the definition of the primary evidence. Now, why this definition is important? Because all being the public prosecutors, you all must be remembering and understanding that when this is an old act, 65A and 65B, the old act never intend to classify digital evidence into primary and secondary. Had it been, they could have defined in primary or in secondary. What the old act or legislature wanted to intend that point of time was that digital evidence is separate class, and for this separate class we have a requirement of 65A and 65B. 65A says digital evidence will be admitted in terms of 65B. 65B says some safeguards, and this says certification is required under clause 4. There are many cases where the court says 65A and 65B are sui generis code, a code of itself when we talk about digital evidence. However, it is the creation of the judiciary or confusion creation by the judiciary itself that many times court started interpreting that, look, even if it is not go as a 65B, it may go under primary and secondary. So Parliament Act case, court admitted the call list without 65B certification, saying that even if 65B is not complied with, it can go as a primary and secondary. There are subsequent cases where court says if it is primary, then no certification is required. So this concept of primary with regard to digital evidence, it all created by judges themselves. And we look into some of the cases now. Probably that might be the reason that when we bringing new law, in the new law, we defined extensively what is primary with regard to detailed evidence. We have not defined what is secondary with regard to detailed evidence. That's again interesting. In the secondary definition, you will not find detailed evidence. Primary we have defined. So what is original, we have defined. And then what we think as a secondary, etc. What was earlier 65B, the same concepts are there. They are all considered as output of detailed evidence, output of computer evidence. So when it is output, you require certification. That was the concept under 65B. The same concept has been taken. So now we got two things. When it is primary, then it is not output. When it is primary, no certification is required. But when it is output, so when we admit in the court, we don't give the main computer. When we don't do mobile, we create image of it. So when we create image, it is output. When you make 10 pen drive, it is output. When you make CD, it is output. So when if it is output of the digital evidences, then the process of certification automatically comes. So that's the basically new law concept. If it is primary, then you don't require certification thing. So primary, they define four explanation. Explanation number 4, explanation 5, 6, 7. Explanation 4, fair enough, there is no confusion. If the file is saved in the computer or mobile or whatever, whether it's it is multiple files are sequentially or simultaneously, they are all primary. So there is no confusion in it. Explanation 5, I have some confusion. That's my own confusion. So you all can might be give help. And why the confusion I'm saying is, let's read what the explanation 5 says. Explanation 5 says, where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed by the other party. Where is my confusion? And then I'll say why this confusion is. My confusion is, any custody cannot make some document primary or secondary. Custody only increases the reliability. Proper custody we find in the old Act section 90. If a document is 30 or more years old, coming from proper custody, there is a presumption that it was properly executed, stamped, etc. So court has increased presumption. So it increases the reliability. And the other party is challenging otherwise, let they rebut it. They can give evidence about it. So custody per se does not make something primary. Unless until disputed, there's nothing under the sky which other party does not dispute. In the criminal justice system, always defense dispute. Whatever you might give, they will dispute. But probably this explanation has been kept for the reason, suppose during the trial, I have recorded something in my mobile and I bring into the court. Other party has no objection. Why not admit it? So considering those situations where some party, I might have something which whatever I record, even today, whatever I do photos and I save here, immediately it goes to cloud. So I purchased Gmail cloud system. It is saved there. So my last 20 years, all photos, all videos, I find some places. So I bring from there and I produce in the court that I have took it, I saved it, and this is my recording. Other party is not objecting. So we can admit. That's by the reason. Remember in the secondary evidence, if the other party do not have objections, many times we admit secondary evidence. Instead of original deed, we can submit the Xerox copy if the other party has no objection. Considering those similar situations here, they have added explanation 5 that if the other party has no objection, let me go for this evidence, which are there is no dispute. So that's why this explanation 5 says. But theoretically, custody cannot make something primary. Custody increases the reliability. So that's the explanation, second explanation, 4, 5. Explanation 6. Explanation 6 says, suppose someone is recording some video. Now nowadays we have a habit of, suppose might be some of you are doing training in YouTube, you are doing live telecast, or in Facebook, live streaming. So if anything is live telecast, live streaming, and many people saved it, when it is live streaming, live telecast, broadcast by someone and all other people have saved it. So if it is simultaneously stored and recorded from and transmitted or broadcast or transferred to another, each of the storage is primary evidence. So whosoever recording those, they are all primary evidence. Fair enough, there is no confusion in it, this section also. Last explanation, again there is no confusion, where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automatic storage, including temporary files, are primary evidence. Give you example, say for instance, says the local police station has a recording system. All the CCTV in the area, they are recorded at the OC office.
One control room is there.
So might be in control room you have at the PS level. Then you have a control room at the DSP level. Then you have a control room at the SP level. All 3 places CCTV cameras are recording simultaneously. All are primary evidence for this purpose. So these 4 explanations make very clear that when in electronic records are primary evidence. When it is primary evidence, when we produce primary evidence to the court, question of certification does not arises, because under when 65B was prevalent, that time also the Supreme Court make very clear in few cases that the primary evidence we don't require. So now they have defined when the electronic evidence can be in the primary form. So these are primary form. Now we come to secondary evidence.
Sir, hello.
Ha, sir.
Sir, I have a question regarding that explanation 5.
Yes, sir.
Sir, please bring that. Sir, this is the rule of evidence that legally admissible evidence should be there in the evidence. So that means legally admissible what is permitted by the Evidence Act. Now question is regarding custody. So that only implies chain of custody. Suppose you have recorded certain things in any gadgets, maybe in your mobile phone or CCTV. But thing is after that, that means present position of law is that when the recording unit, original unit is produced, that is to be considered as a primary evidence. Right, sir. But when there is a custody of, the question arises regarding the custody of that primary document, maybe sometime it is used for analysis by SFSL or CFSL, whatever may be. So in the official process, 3 or 4 persons are involved or stages are involved. That is from the police station, that is the constable carrying to the place, and also the court is concerned. So a lot of stages are there.
All chain
So
of
it is
custody, yeah.
up to the prosecution to prove that regarding the chain of custody. So that's why it is written as unless it is disputed. So that means unless it disputed means the chain of custody is always disputed by the defense or the accused. So when the electronics or digital record is produced from proper custody mode, that means we have to prove, the prosecution has to prove regarding the genuineness of the custody.
Okay.
The record is supposed seized. It is not in the Malkhana, not recorded in the Malkhana. Whatever it was kept with the officer or any other person. So now it became the burden as far as explanation 5 is concerned. Produced from proper custody. Then only such electronics or digital record is primary evidence. So
Okay.
before that it was not there. And regarding admission of the or admissibility of the evidence of electronics evidence. So another aspect is the report of the SFSL is concerned, that is the output. That is the output. So that in that time or in such situation, we have to go for 65B certificate. As because it became a output either in the hard disks or in the paper, whatever it may be. So in that stage, that required 65 application of section 65. Secondary evidence as like a secondary evidence that is regarding the contents, or if the primary document is played in the court of law and prosecution has proved that it is a primary document, then no certificate is required.
Yeah, okay. Yeah, I agree with you. Only thing is that it is not that a primary evidence can be on all 4 clauses. So even in some circumstances when it does not fall under clause 5, but explanation 5, because when we look at the interpretation of the statutes, in the interpretation, these are the 4 clauses are giving, clearing 4 ways in which we can interpret the primary evidence. So in the primary, if it does not fall in the clause 4, we have to see clause 5 or explanation 5. If it is falling under explanation 4, fair enough. If it is falling under clause 6, fair enough, or 7, it is fair enough. Clause 5, my impression is when this says, probably considering those situations where if both the party has no objection, why to restrict, make admissible. So those what you giving which are there in those will automatically come. They may fit into either explanation 4 or may explanation 6 or may explanation 7. If it is certification is required. If it is not output primary, then certification does not require. So in those circumstances, if there is objections, etc., those clause 5 is not applicable. So this is one of the 4 ways in which this electronic evidence primary is being explained. So we need to exclude that. It's not the exclusive, that is all the 4 criteria to fulfill. Out of these 4 explanation, one can justify, that's fair enough. If suppose Malkhana has seized some primary, mobile is seized by the police and that is there in the Malkhana. Malkhana says, yes, from that day it is there with me. Bring to the court. Other party has no objection. Primary? So if objection is there, it will not come in clause 4. It will not come in clause 5. It can go to other clauses. And if it is output, then in those circumstances, we require certification. So in that way only, we can look into clause 5, clause 6, and clause 7 also. So that's basically the primary evidence thing. Let me see secondary evidence definition. Sir, manipulations can be at anywhere. Only thing is how we are going to prove the facts in the court. So probably because in clause 5 they says that unless it is disputed, basically it's kept in option open that if the other party has no objection, let we admit. So could not exclude it because of the rigidity of the law. If other party is not objecting, let admit it. Secondary evidence, again I have similar confusion. Secondary evidence. Clause 1 to clause 5, whatever is there earlier, the same thing is there. So no changes. So I don't need to go into clause 1 to clause 5, because earlier also 63, the same 5 clauses were there. What is new in the new law is clause 6, clause 7, clause 8. Clause 8, I don't see any difficulty. Clause 8 has been incorporated, keeping in mind that nowadays when the police investigate, there are several cases where enormous amount of documents involved. When enormous amount of document involved, in those circumstances, might be some expert can be appointed, a chartered accountant can be appointed, chartered accountant can analyze all those documents, make the report based on them and give their opinion. That here in clause 8 says they are secondary evidence. Earlier, this is also a ways to give secondary evidence. When there is an enormous document, expert is giving opinion, instead of the original, they can give the Xerox copy along with the opinion. It can be admissible as a secondary evidence, permissible. Here they say this expert opinion along with the document, this can be considered as a secondary evidence because they have enormous document, they have to analyze, scrutinize and prepared their own report. Explanation 6 and explanation 7. Oral admission. It is beyond my understanding why it will be secondary evidence. Oral admission implies if I admit something orally to sir, in the court he will go and give evidences that Mr. Khan has admitted this thing. Admission or confession. What I admitted was oral. What he is saying in the court is oral. When it is oral, then it can be either direct or hearsay. Hearsay admissible in some circumstances. Here it is admissible. Either it can be direct or hearsay, it can be admissible in oral sense. So the oral admission, how can it be secondary? Presumably, again I can just presume, presumably the drafter of these provisions might have an idea that something which is in my knowledge, it's a primary. The knowledge which comes through other persons, it is secondary. But that's not the concept of evidence law. Evidence law, when they define primary and secondary, it defined in the context of only documentary evidence. In fact, Evidence Act, the only clauses, clause 5 is the only circumstances in entire Evidence Act where someone make oral statement in the court and that oral statement deemed to be considered as documentary evidence. Clause 5, is it, sir? Clause 5 is the only circumstances.
All five states to contents of document. Section 90 says document is the best evidence. And when a person is stating about the contents of a document,
Yeah.
that cannot be a primary evidence.
No, it's not the primary. I'm not saying primary, sir. I'm saying this clause 5 of section 63 earlier, same language. Now this difference has the same language. This clause 5 is the only circumstances in the Evidence Act where someone is making a statement. He is making a statement about the content of the document. So when he is making a statement, he is saying orally in the court. But when it is recording in the court, is it recording as a oral evidence or documentary evidence? Sir, it is clause 5 is documentary, secondary. Clause 5 is secondary. So that's the exception in the Evidence Act, that there is only one circumstances when we make oral statement, but when it is going to the court, it is going as a documentary evidence, because whenever we use the word secondary, it is documentary. Whenever you use the word secondary, it is documentary. Secondary cannot be oral. Oral can be oral, direct or hearsay. When we say secondary, means documentary. So that's the only circumstances where someone make oral statement, but it is deemed to be considered as secondary evidence. So that means a documentary evidence. Now these three clauses which has been added, clause 6, 7, 8, one is about the oral admission, other is about the written admission. Again, in the written admission.
Admission part is concerned. Admission. Old Evidence Act, there is a admission.
Section
21.
31 or 21.
21.
So admission defined in 17.
In that perspective, the oral admission, that may be of the accused, may be of the witness, that is not in the court. In fact, not in the court, the evidence of the case. That is not evidence. admission, whether written argument, written admission or oral admission. Something like this.
Okay. When
Cannot be, but said that it is just a secondary evidence in the court of law. It is evidence is classified primary and secondary.
when it is document, when it is document, then it is primary and secondary.
It is admission.
Yeah.
Take for example, admission by the accused. Comes under that, not a confession.
No, admission by the accused can be oral, can be documentary. So accused say every day I commit a crime and maintain a diary. I write in diary detailed things. After 5-10 crimes, police raided my home, they seized my diary. Every detail, my confession is recorded in a diary. Whether this diary documentary form, it's my admission, because what is confession is nothing but admission. This diary, is it primary or secondary?
And it's a primary.
It's original primary. But here they defined written admission as secondary. In explanation 7. Written admission, secondary. So probably written admission again, what the legislature intend, I can only guess, because it is beyond my imagination. As a teacher of evidence law, I am teaching from last 20 years.
Giving an example
Yes, sir.
for restriction of the fact. The accused came to the police.
Ha.
Stated some fact.
Yes.
That was entering the station diary.
Yes.
And according to one officer is deputed
Yes.
to find out the truth. And he found that there is crime. And this is as per the admission of the accused. It is not a confession.
ठीक है.
My question is whether that diary, the contents of the diary, diary means station diary, as a written admission or a secondary admission.
Okay. Okay. It is because this written admission has not been given by the accused himself. Suppose the accused went with the letter that yesterday I committed this crime, etc. I am informing you, I voluntarily, you take proper steps. Accused written everything. It is written admission. When accused make statement to the police orally, it's an oral admission. Police is writing it. I am not coming what is admissible, what is not admissible. Police is writing it. Then it is admission is orally recorded by the police, then put in writing. Will that paper will go to the court? My answer will be maybe, depending on if it is confessional part will go, other than confessional part will come. For example, accused, I seen in the newspaper, it's a Odisha case. I've seen in the newspaper sometime a year or so or little ago. A lady committed murder of his wife, her husband. After committing murder of the husband, along with the head of the husband, she reaches to police station and said to the police that I committed murder of my husband. This is head, dead body is there. Police recorded the statement. The part which are confessional, not admissible, hit by 25. But the conduct of the lady, admissible. The dead body head which she brought, admissible. Other than confessional part, and the statement by which the remaining part of the dead body will be found, 27, it will be admissible. So depending on the circumstances, which is prohibited will not go, which is other than prohibited can go. What the police seen themselves, police officers seen the lady is coming with head. It is her subsequent conduct. So it will go. So depending on the situation, if you can justify the relevancy, it may go. My only contention was that admissions can be primary, it can be secondary also. Written admissions could be primary, can be secondary, but here they says the secondary, and again I'm not sure why they said the secondary. Probably again, presumably, again keeping that in mind, that when something is in my mind, it is primary. When I'm writing something on paper, it is secondary. But probably that's not the principle of evidence law. Principle of evidence law implies that primary, secondary, it is in terms of the document which we create. So as an accused, suppose I am writing every day my sin, whatever time committed, and police sees it, that diary is primary evidence for the purpose of my case. If the diary become exhibit in the court, tomorrow someone wants copy from the court and court issue certified copy, That certified copy becomes secondary evidence of it. So depending on those circumstances, evidence can be primary and secondary. I'll just take a call. My vice chancellor is calling on me. Yes, sir. Okay, so that's.
Give an example. Lots of complaints, solar administration, plus second evidence.
I don't have any real examples to give you. My only impression is might be the status that court legislature might have thought of, that if something in my knowledge it is primary, when I given to you secondary. Oral admissions can never be primary and secondary, sir. Oral admission, what's happening? If I am orally admitting before you, you are going to the court give evidences. So you give court evidences, it will fit into that evidence first part orally. Is oral evidence. What I said oral evidence, it will not be documentary evidence. Primary, secondary, when we say, it is only talking about the documentary evidence. So there is some, I think some gap, or the people who drafted it, there is some omissions on their part, but I cannot comment at this point of time. Probably they might have in their mind that what is in my mind is a primary, what I written to say to other persons are secondary. So when it comes to my mind, mouth, it will be primary. Oral is a primary, and what's come from the other is a secondary. But primary, secondary is not that what they have in their mind. But this is a secondary definition. Now we have many things to discuss, and otherwise we'll miss. 61 is a new section. 61 is a new section which you can read yourself. This section is talking about a general principles in respect of digital evidences. It says general principles, and the general principle is only says that there is nothing wrong if something is a digital in forms. We cannot say that it has a lesser value. हाँ सर जी सर हेलो सोन আসছে না স্যার হ্যাঁ শুনেছি হ্যাঁ স্যার হ্যাঁ স্যার হ্যাঁ স্যার হ্যাঁ স্যার স্যার 15-16 না স্যার আমি তো আসাম যাচ্ছি স্যার 16 থাকবো স্যার 15 আমি আসামে আছি 16 আছি স্যার হ্যাঁ স্যার ঠিক ঠিক স্যার ঠিক হ্যাঁ স্যার হ্যাঁ হ্যাঁ স্যার ওকে স্যার হ্যাঁ 15 তারিখ রাত্রিবেলায় ফিরে আসবো স্যার ঠিক 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 হ্যাঁ স্যার হ্যাঁ 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 এভিডেন্স বিএনএস এর দুটো নিতে পারি যেটা বলবেন স্যার হ্যাঁ ঠিক হ্যাঁ স্যার ঠিক 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 স্যার ঠিক sorry when boss call, so we are outside the university. So nothing, so this is 61. Now 61 is a general principle. The general principle is that if something is digital format, does not mean it's a lesser value, it has the same value. That's a basic thing which the 61 says. So basically under the new evidence law, the whole thrust is that we will rely more and more digital evidence. We require detailed evidences, and that's why the primary definition are included in the detailed evidences. So 61 general principles. Now we come to 62, which was just basically earlier it was 65A. So what the 65A say earlier? The electronic evidence will be admitted through 60 as per 65B. So that what 62 says. The electronic detailed evidence will go as per section 63. Now we come to 63. Clause 1. Language is same. Whatever the language is earlier is the same language. Notwithstanding anything contained in this adhiniyam. Here what we require to understand, I am reading was only to understand this computer output word. So notwithstanding anything contained in this adhiniyam, any information contained in an electronic record is the same language of 63, 65B. Record which is printed on paper, is stored, recorded, copied in optical or magnetic media, or semiconductor memory, which is produced by a computer or any communication device, or otherwise stored, recorded or copied in any electronic form. So whatever it is copied or recorded in electronic form, this will be considered as computer output. So what is primary? As soon as we transfer something primary to other device, they are all computer output for the purpose of this law. So they are all computer. So shall be deemed to be also a document. They are all documentary evidence. The same thing which was there under section 65B clause 1. There also they have used computer output. Here also they have used computer output or output of the detailed evidence. Loosely we normally say, but the word they have used computer output. When it is computer output, A, B, C, D in clause 2, they lay down some safeguards. When this computer output was saved or recorded, computer was functional, or maybe at the time it was not functional, but when it was saved, it was functional, or maybe it was not functional now, but non-functional is not such which will affect the evidence. So there is some, these are the check. So if this check is there in respect of those computer output, then it can go in evidence. Then come clause 3. Clause 3 says this computer output can be by single computer. So I might have my own laptop, might be the network of the computer, might be many computers are connected with. So any of from them, you got this material. When police go to raid a cyber cafe or maybe call center, nowadays so many frauds are happening through call center. So in call center, you might have 50 computers, all are connected. So any one computer from where you can take, that is as good as whether it's a computer network, computer generated, they will all computer output. So that's what the clause 3 has defined. Now we come to the clause 4. Here it says, in any proceeding where it is desired to give statement in the evidence of this section, a certificate doing any of the following things shall be submitted along with the electronic record at each instances where it is being submitted for admission. So there is the need for certification. A certificate required to do any of these things. Basically, when I copied, I transferred, it was functional, it was proper, etc. Those safeguards with which it is required to give certificate. Earlier also the same certificate formats are there. If you see the language is same what was there, 65B clause 4. Now the under section 63 clause 4. So what was 65B clause 4 now becomes section 63 clause 4. Talking about the information shall be taken to be supplied to computer, communication device, it is supplied there to in appropriate form with or without human intervention. So whether it was you copied from computer to other manually or by using algorithm or by using some software or maybe AI generated copies. Whether you directly saving it or you have a system where in mobile you have a AI supported device or some apps which automatically download the live telecast video. Those all can be considered as an output for the purpose the certificate is required. Now the issue arises was, so we require certificate under section 63 clause 4. Why the principle of this primary evidence comes was, remember very early case, Parliament Act case, Navjit Sandhu. In this case, call list was admitted. Now there was no 65B certification. So Supreme Court in this case says, look, if this is not certified, no certification of 65B, then it can go as primary and secondary. So if it is a printout, then whatever there in the system is a primary, this is secondary, so it can be admissible under 63. So if it is not 65B, under 63, we can admit as a secondary evidence. So court in fact admitted the evidence in that case and the persons got punishment also. After Navjot Sandhu case, then very important case which came was Anwar PV versus PK Bashir. Now Anwar PV versus PK Bashir, it was about an electronic record. And their Supreme Court says that no, electronic record certification is mandatory. Why it's mandatory? Because the electronic records are more susceptible to tempering, alteration, transposition, excisions. So it will easily change, it will easily alter. So safeguards are provided to ensure the safety of all those devices. And that's why certification will at least check that there is no manipulation or changing to that device. So that's the decision which the Supreme Court says in Anwar P. Bashir. Court says also, the court held that section 65A and 65B form a complete code. They say these two sections become an independent code for electronic record. Complete code when it comes to admissibility of information contained in electronic record, and an electronic record by way of secondary evidence shall not be admitted unless the requirement under section 65B are satisfied, including a written certificate under section 65B clause 4. So it become a complete code. We require certification without which we cannot admit the output of electronic record. It was further held that the Evidence Act does not contemplate or permit proof of an electronic record by oral evidence if the requirement of section 65B are not complied with. So that has to be complied with. However, is created by the court. However, if an electronic record is used as a primary evidence under 62, then same is admissible. So this primary and secondary confusion generated by the court. Legislature never thought of. Legislature says 65A and 65B on the electronic record. So court, even earlier case also court says primary and secondary in parliament attack case. Here also court says if it is primary, then not required. So primary, secondary, they should come. After this, we found in this case is basically Shafi Muhammad. And in Shafi Muhammad case, again Supreme Court changed the view. 2018 judgment. And Supreme Court says that look, in India, we admit illegally searched materials obtained by illegal search admissible. So India, we are not rigidly follow. Like we have in USA, there is a concept which called fruits of the poisonous tree. If the tree is poisonous, fruits are poisonous. Because US Constitution says anything obtained illegally is not admissible. In India, we don't follow that system. In India, what we follow is tree might be poisonous, fruits are fruits, so we can eat it. There's no difficulty. So any if it is obtained by illegal search and seizure, admissible. So in this case, Supreme Court says that this requirement of certification under 65B is procedural. So many procedural now we compromise. Search and seizure we make admissible. So says being procedural requirement we can waive. So again bring back to earlier condition of parliament attack case. So 2018 again the things change from the what was there in parliament attack case, same situation there arises. And thereafter we got a case called Arjun Pandit Rao 2020 judgment, and that's the current positions. Arjun Pandit Rao says that no, 65A and 65B are a special provision, a complete code, a sui generis method. So any electronic record to be admissible, it has to be in compliance with section 65B certification. So without certification, we cannot admit any electronic evidences if it is output. But in Arjun Pandit Rao also they say that if it is primary in nature, then it can go without certification. So it has not disregarded that. So primary can go, but if it is output, we require certification. Without certification, it cannot go. So comes within the admissibility of this act. After this, we have another case of 2022. We just follow Arjun Pandit Rao. So nothing has been changed. So admissibility of electronic record, certificate under 65B4 is mandatory. For production of electronic evidence, oral evidence in place of such certificate cannot suffice. You cannot give oral evidence in these places. So mandatory certification. So we see the changes which has gone. So it's all the judicial product, whatever our intention was. And that might be the reason that now in primary evidence, the legislature has defined that in certain circumstances, the electronic evidence can be primary. As because it is primary evidences, question of certification does not arise. But if it is output, then we mandatorily require certification under section 63 clause 4. So certifications are mandatory. There are other sections also, which is basically just replica what was there earlier. So 67A is basically 66, which was earlier 66. Electronic signature presumption has been added. 73 verification of the digital signatures. 73 is what was 73A earlier. Then 81 electronic or digital record. Agreement. So these are all different sections, which was earlier also the same section they have copied. We don't need to go into detail. Again, digital signatures, etc. Some presumptions are there under 86. Now, these are the two forms. These two forms which we find in the annexure of Bharatiya Sakshi Adhiniyam. So, when under section 63 clause 4, we have to certificate which we say earlier there is no standard form. So, every district has their own method. So, one SP come, he says the subordinate that write form in this way. So, whole district follow it, other district follow the other system. So, there is no uniformity. Now, we have one uniform process.
Those certificates are not in control of the law. So far as I have seen, cases, all the certificates under section 65B, what are attached to now in different case records, are not in consonance with law, because sir, in the certificate they have not given regarding the identity of the document, identity of the computer or the electronic instrument by which they have brought the material. So
That's true, valid point.
So if that certificate is not, if there is no correctness of the certificate, then that part of evidence is not admissible.
Definitely the reliability will decreases. Whether they will confirm with the conformity of the certificate or not, that issue comes normally. Now, one thing is that because earlier there is no specific model or no specified form, there is a difference in the certificate throughout the country. Every state has their own method in which they retain the certificate. Now we got a form, a standard format, but very rigid format. Why I'm saying rigid is, you see the detail what they have to write. Initially, the persons who can give this certificate, you see, own, maintained, managed, operated. Many a time when police personnel will go with some expert, operated they will carry tick. Because if you make certificate by someone from the call center, they will hostile tomorrow. So some other persons normally do. Then the model number, make number, IME number, all those details need to be filled up. Most importantly, I state that hash value of the electronic digital record is dash 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 obtained by following this algorithm SHO1, etc., etc. So because they have to follow different software by which they copied this in the device, whether it's a imaging or clone they have done. And when they do imaging or cloning of it, it maintains the hash value, because the same thing will go to the forensic expert for second form, form B. Part A by done at the time of seizure. Now, what's the difficulty will come? All the search and seizure has to be videograph. If you are seizing the electronic record, this entire detail has to be filled up at the scene of crime we are doing seizing. There we have to prepare the hash value. Now, hash value preparation, technology wise, it takes time. Might be tomorrow technology may become super fast, but presently, if my computer, you have to prepare the imaging of it, clone of it, or it may take few hours. So the search and seizure who police officer will do, they have to go to the search and seizure by Boria Bistra Saath mein. So they have to stay few hours there, do entire thing, complete this form, and entire thing has to be videographed, and this form need to be prepared along with the hash value.
Sir, can the police officer during investigation seizure find the hash value of the document?
Someone has to fill up this form. How you do the fill up? So only
Sir,
to
there is a special procedure regarding seizure of electronic instrument, and if he is not well equipped with the electronic knowledge, so there is every possibility of tampering of the data during the finding of that hash value.
that's may happen. So that's why now the So either the police department have to manpower, technology wise, they have to upgrade themselves, or they have to carry some manpower with them who can do it, because for finding hash value, they have to use some software, without which the hash value will change. From my computer, if you copy a photo, the hash value which is there in my computer, which is there in pen drive is different. Unless we copy through following some software, like which are mentioned there, SHA1, SHA256, MD5, there are new technology will come, which can be get. So whatever method we follow, then only the hash value remains same. And so what the foolproof thing is, then the form B will come. Form B will signed by the expert. It will go to the forensic expert. Forensic expert will fill up this form. Now, if the first hash value and second hash value is same, at least it is full proof of the matter that there is no tampering, no change from this file to this file.
Sir, regarding seizure of electronic document, there is a special procedure. And whenever the investigating officer will seize a mobile phone, it is his primary duty to keep this mobile inside an air Faraday bag, where there will be no communication to that bag. And that instrument is to be sent to the forensic lab. Because if the data is operated by the investigating officer, then there is every chance of corruption of data. So there is chance of tampering. So in a electronic class, they have told that whenever the police officer is sitting in electronic instrument, and either if he is well aware about the electronic evidence, then he may seize. Otherwise, he will take the assistance of the electronic expert who will seize so that the data will not tamper. Now, you are saying, sir, that the police officer will find the husband. So if the police officer will find the husband, there is definitely the chance of corruption of data.
So now the issue, that's the challenge is, suppose if the police is seizing a detailed record, for the detailed record, they have to fill up this form, certification. When they have to fill up this certification, this certificate itself is the requirement of the hash value. And that has to be determined by following the software. So now the police department has to cope up with these challenges, because the hash value in the form you have to write. And if this hash value at the time of seizure and hash value which is there with the forensic expert, if those does not match, then the confusion can be raised.
There is some censor.
Huh? So there are always some things happen. Change ho jayega automatically. So that's why at the time of seizure, and that seizure is now you are doing under videograph things. तो पहले का तो है नहीं कि आप कैसे सीज कर रहे हो. नाउ वीडियो इज गोइंग ऑन, उसी में आप रीड कर रहे हैं. माइट बी वन कांस्टेबल पट्टी लगा लेगा, यहाँ पर कैमरा रहेगा, रिकॉर्ड करता रहेगा दिन भर का. So all this will come. So this is become much more friendly to the victims or citizen at least, but it is a challenging for the law enforcement agencies, police officers. Definitely it is challenge. The manpower is required to be built, and might be technology can give answer to technology only. Okay, now we come to other things. So we have just 10 minutes left. So there's another thing where the changes are there. Public document. Is the same section 74 earlier. I said that's the only section there is no changes. Earlier it was 74, now also 74. Only thing is what was 75 that become clause 2 of 74. So all other document is private document. So public document, then private document. In public document, again, all of you know, but just for clarity, we find two categories of documents are there. One which are pure public document under the clause A, and B, not so pure public document. They are basically private document, but by virtue of their keeping with the public authorities, they become public document. That's fall under the clause B. So not so pure public document. In public document chapter, there's a many these unnecessary things were there. Parliament of the UK, Provincial Act, London Gazette, Commonwealth, all these has been deleted in the subsequent section of 77 and 78, etc. Now we come to, that is a part 2. So there is no changes in the other things there in part 2. So part 2 we have seen the on documentary part. On document, when we say documentary evidence, the document can be classified into 3 ways according to evidence law or BSA, which was there earlier. One classification was primary and secondary. Other classification is public and private. What is third classification? There is another classification called document which require attestation, document which does not require attestation, because the Evidence Act has treated both the categories differently. If a document mandatorily require attestation, then for proof of it, you require at least one attesting witness to come to the court and give evidence. If the attesting witness is dead, then at least someone will come who can identify the signature. So you have a specific procedure for the document which require attestation and the other thing. Now we come to the last part of the Evidence Act. The last part is under the new law from 104 to 170. Earlier it was from 101 to 167. So what are the things in this last part? The first thing is burden of proof, 104 to 120. Now here the burden of proof in 2 categories. One, which is pure burden of proof provisions like 104, 105, earlier 101, 102, 103, 104. Then because of the presumption, burden shifted. So that also fall in that category. So you'll find a large number of sections where because of the presumption, burden has shifted to the other party. So 104 to 120, they're talking about burden of proof. Same thing what was there earlier is remain in the new law. There is no changes. Section number has changed. Estoppel, again the same thing what was there earlier, 115, 116, 117. Under the new law, 121, 122, 123. Then witnesses, 124 to 139. Earlier it was one from 118 onwards. Examination of witnesses from 140 to 168. Same provision, there is no changes here. In witnesses, some minor changes are there, which are basically merger of the sections. Then 169 is improper admission and rejection of the evidence. The same thing as well earlier also. The same thing we have kept in the new law also. Okay. So when we see the last part of the Evidence Act, there is no major changes. What was earlier, that's remain in the new law. Section 126, 127, both are merged now, become 132. Remember, very interesting thing is for the lawyers in the evidence law. For all other privileged classes, you will find only one section. Husband and wife, one section. Police officer, one section. Affair of the estate, one section. Official communication, one section. When it comes to lawyer, 4 sections. 126, 127, 128, 129. Because the lawyers, juniors, lawyers clerk, all are protected privilege communication. So they are 126 and 127, they are now merged and become one section now, 133. So for lawyers now 3 sections, 132, 133, 134. In 3 sections, they talk about the lawyers. So section number has changed of all the sections. And this is the merger of section 126 and 137. Under the new law, it is 132. That's the change in the new law. Now the last section. So what we discussed till now, that okay, we got Evidence Act going to repeal, we are going to get new law, but read the last clause, and last clause says, notwithstanding, first clause says Indian Evidence Act is hereby repealed. Clause 2 says, notwithstanding such repeal, if immediately before the date on which this adhiniam come into force, that means 31st July, there is any application, trial, inquiry, investigation, proceeding or appeal pending, then such application, trial, inquiry, investigation, proceeding or appeal shall be dealt with under the provision of Indian Evidence Act as in force immediately before the commencement, as if this Avinium has not come into force. So that means Evidence Act and the Bharatiya Saksha Adhiniyam both will go parallelly for quite long time. We are not going to get rid from the evidence law in recent near future. In some old cases, we have to deal with evidence law. So last part, as if it has not been came into force for all those cases. So all old law, this evidence that will apply. Hopefully that tomorrow might be the Supreme Court in some cases may come up with some directions that Evidence Act law may apply retrospectively. Because the procedural law can be retrospectively applied. But because it says in clause 2, we have no option. We have to go by the old law. So that basically the provision which are there under the Indian Evidence Act. If any questions which are there on the evidence law, a few minutes left, we can discuss that. Any questions, sir? Anyone? Have you able to understand all the changes which are there in the act? So no confusion. So like it's not something great changes. So nothing to panic. So there's a panic that we are going to get new law. It's all old wine in new bottles. So, yes, sir.
Sir, if the appeal file if the appeal has not been filed and the certified copy already applied and the new law came into force, then what is the situation?
Sir, was same question, na?
Yes, sir.
He asked the same question. Any appeal is continuation of trial. So that principle we follow. Then you decide which law will apply.
Already appeal has not been filed. No?
Even if it's not filed, when you go for appeal, it is a continuation of the trial. It's a continuation of earlier proceeding, and accordingly, old law will apply. The same principle, sir. It's not new thing. Yeah. Even if it's not pending, it will come in the old law. And that's the common sense. That will be the best way to interpret, because we have to interpret in such a way which can serve the purpose. So last clause purpose will serve in that way only, that appeal will go in the old law only, not in new law. Yeah. हाँ सर बोलिए सर. Yes sir.
DSP or some technical person. Technical person is do the and so we will give the
Okay. The best person which could have given the certificate was the call report creator, the company, but they don't give. Normally they send the mail to the, as you said, that's the process are there. So to fulfill the requirement, all our transactions, because these are the challenges in the electronic record. Electronic record communications are much faster, much easier. It goes from one person to another, other person to another. So it is the persons who last going to give evidence, your department. So any persons in the commissionerate office, police department who receive it, they will give certificate that I have received this email. This is the call detail report which comes from the office, and that will be admissible. Has value detail in those circumstances. Then the issues come of this form, because the form is all clauses are mandatory. In the all clauses, the highest value is mandatory. So we can give output in the printout. So highest value we cannot give. What is the file content in the your computer? That has value can be generated.
Which produce the document. Last computer.
Only last computer. Last computer, that hash value computer file will say hash value. That can be given. That's the only way out, sir. No, printed copy. No, but they printed to from soft copy, na?
No need.
Giving the certification.
Regarding such a signature provides no person to send message to the experience guy. Then practical way, the investigating officer, that is the IAC, police station, which is containing his right from the position of an informant. Because there will be a delay in the reaching people to police station. The IO will reduce the affair into writing, and he will take the affair, he will withdraw the affair and send it to the court. So the person, the BNSS provide the informant by electronic means. He can be an informant and to appear before the police station within 3 days. So now, if the concerned police station reduce that from that material into writing and send the same to the court, the status of the person who sent the message first has turned to be a witness than the informant.
Okay. Now, informer case is different, sir. Informer case we can keep in complete different pedestal because all informers are, police informers are a privileged witness. They are privileged witnesses because they cannot be, no police can be compelled to disclose the name of the informer. So when police get any information through informer, police even in, they don't write the informer name. They say I got from information from reliable sources, and that's good enough. So it will be in most cases, it's a sumo FIR.
No, sir. That part is kept for security, for the security of the person. But whenever the person is interested to proceed to the police station to lodge a FIR, so the statute provides in 3 days time. So why will I worry for I have given the message to police station today. The statute provides me 3 days time.
I will come on 3rd day only.
I will come on the last Monday. But by that time the ISA already arrested.
Then it will be sumoto FIR. That's the only way out. Yes, sir.
Sir, regarding the FIR, when the person lodge the FIR in digital process, the law is clear that is the signature, digital signature in admission as a primary evidence. Digital signature is admitted. When the FIR lodged by
Okay.
email, the signature of the digital signature is admissible by law as a digital signature.
Okay. When we say digital signature, we need to understand there are 2 categories of digital signature. One digital signature we say secure digital signature. Secure digital signature is created by certifying authority appointed by the government who can issue a digital signature to persons. So any corporate who has to submit the annual return of a company, they all have their digital signature, and through digital signature they sign. In fact, when we get the income tax return, in that form, you will find on the ground side, the concerned officer has signed the detailed copy. So lakhs and lakhs of copy their signature. This is as good as physical signature because for this, there is a presumption also under the Evidence Act that digital signatures are of that particular court shall presume it is the genuine digital signature of that particular persons, and court shall presume in favor of that digital signature. So there is a presumption in favor. So the question is when someone will register an FIR with digital signature. So for the secure digital signature, still we have to wait for the rules. It might be that the government will come up the rule which say that suppose if when I can submit my annual income tax return by the digital signature, all the companies SEBI compliance are by digital signature. There's a process in which we have to put the digital signature file in the computer and then we can sign all the files. It is as good as physical signature. So that the legislature might in the rules will come up with some way that the signatures can be either physically going in the police station or by digitally by digital signature. Signature by digital secure digital signature is different. But when we send a mail and it carry our signature, now these are unsecured digital signature. This is not considered as signature for the purpose of execution. In many places in India, now this agreement can be signed, but digitally. You can sign through but that is secure digital signature by the digital signature which are issued by certifying authority. So there is a certifying authority of the government which issued digital signature to you. By that signature, you can sign the document, you can sign annual return, you can sign almost all document when you submit to SEBI or other statutory body. So might be by rules this clarity will come, but definitely not unsecured digital signature. They have to come and sign. But this exception of digital signature might come in the rules. Now, mandate is they have to come to the police station and sign physically. So that's the main mandate is there in the law. Okay, sir. Thank you, sir. सबका बहुत बहुत ওটা লাগবে এখন ইস্যু হচ্ছে যে ফাইলটা কম্পিউটারের মধ্যে লাইক হ্যাজ ভ্যালু অফ দ্যাট ফাইল নিড টু বি জেনারেটেড এন্ড দ্যাট রিকোয়ার এক্সপার্টিজ has increased